Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in docket number 202263E. Today is Friday, July 30th. It is approximately 10:30 a.m. Let's take roll. Joining us virtually, we have Commissioners Caston, Irvin, Thomas, Powers, and do I see Commissioner Williams? I don't see Commissioner Williams unless my eyes are playing a trick on me. Present in the hearing room, we have Vice Chair Belzer and Chairman Williams. I'm just waiting for my live stream producers to confirm whether or not Commissioner Williams is with us. Oh, okay. All right, and there goes Commissioner Williams. Let's get started where we left off yesterday. Please call your next witness.
Thank you, Mr. Chairman. Brett Braceward again on behalf of the Duke Companies, DEC and DEP call Kendall Bowman to the stand. Good morning, Ms. Bowman. Would you please state your full name for the record?
Miss Bowman?
I'm sorry, I jumped the gun.
Oh, that's fine. That's fine. I appreciate your eagerness. Ms. Bowman, if you would please pause to be sworn in by our court reporter. Is everybody okay?
Yes, I can't hear the court reporter.
If you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, Ms. Bowman. I knew you were going to tell the truth anyway, so I jumped the gun on that, but we'll get back to where I was headed. So would you please state your full name for the record?
My name is Kendall C. Bowman.
And by whom are you employed and in what capacity?
I'm currently employed as Vice President, Regulatory Affairs and Policy for Duke Energy in North Carolina.
And can you please summarize your professional experience on behalf of the Duke Companies working with issues related to PURPA?
Yes. I'm a licensed attorney in Florida and North Carolina and have worked in the utility industry since 1997. In both my prior role as an attorney for Duke Energy or its predecessor companies, and now in my non-legal regulatory affairs role, I've developed extensive experience with the legal requirements states must follow in implementing PURPA, as well as the policy objectives underlying PURPA. I'm also familiar with the history of PURPA implementation in both South Carolina, North Carolina, and have previously testified before FERC and the North Carolina Utilities Commission on PURPA-related matters.
Thank you, Ms. Bowman. And did you cause to be pre-filed in this docket direct testimony consisting of 37 pages?
Yes.
And do you have any changes to that pre-filed testimony at this time?
No, I do not.
If I were to ask you those same questions today that appear in your pre-filed testimony, would your answers be the same?
Yes.
Thank you. Mr. Chairman, at this time, I'd ask Ms. Bowman's pre-filed direct testimony be entered in the record as if given orally from the stand.
Ms. Bowman's pre-filed direct testimony will be entered into the record as if given orally from the stand.
Thank you, sir. Ms. Bowman, and you did not have any exhibits with your direct testimony, is that right?
That's correct.
Okay. And Ms. Bowman, now I'd like to walk you through a brief summary of your direct testimony to provide the Commission an overview of the issues related to PURPA implementation that you address. I'd like to start on with pages 4 and 5 of your direct testimony where you provide an overview for the Commission. Can you please summarize that testimony for the Commission?
Yes. My direct testimony addresses the legal principles and policy issues related to the implementation of PURPA that are raised by Cherokee's complaint. Specifically, I discuss how rates paid to QFs must be limited to avoided costs to be lawful under PURPA. I also explain that DEC and DEP are separate electric utilities that have independent mandatory purchase obligations under PURPA. There is no joint obligation of DEC and DEP to purchase QF output. I then provide an overview of FERC policy regarding legally enforceable obligations, or LEOs, and show that Cherokee's actions demonstrate that Cherokee never made a legally enforceable commitment to sell and deliver its capacity and energy to either DEC or DEP over a specific future term as required by FERC's regulations. I then address the first year of capacity need concept from a policy standpoint that informs avoided capacity rates paid to QFs. Finally, I explain the QF's obligations under PURPA and FERC's rules if the QF desires to transmit and deliver its power, known as wheeling, for sale to a utility other than the utility to which it is directly interconnected.
Thank you. And then on pages 5 through 16 of your direct testimony, you provide legal background on the PURPA avoided cost framework. Can you please summarize that testimony for the commission?
Yes. PURPA was enacted by Congress to encourage development of non-utility owned cogeneration and small power production facilities by mandating that these facilities have the right to sell power to and purchase backup power from traditional utilities. PURPA also expressly focused on controlling costs for consumers. PURPA requires utilities to purchase power from QFs at rates that are non-discriminatory, in the public interest, and just and reasonable to the utility's customers. To meet these standards, PURPA and FERC's implementing regulations prohibit a utility from paying a QF for its power at rates above the purchasing utility's avoided costs. The intended result is that utility customers remain indifferent between the utility purchasing QF output on the one hand, or producing the power itself or buying it from another resource on the other hand. I also highlight that in South Carolina, the cost for power purchased from QFs is paid by the company's customers through DEC's and DEP's annual fuel clause proceedings.
Thank you. And under PURPA, do the QF's operating costs or the level of profitability required by its investors have a role in calculating a utility's avoided cost?
No, as I explained in my testimony, PURPA was not intended to force utilities or their customers to subsidize QFs. FERC has made clear that a QF's operating cost or its investors' expected return on investment are not relevant in determining the utility's avoided cost.
Thank you. And then turning to your testimony on pages 16 through 19, you address the company's independent obligations to implement PURPA. Can you please summarize this part of your testimony for the commission?
Sure. DEC and DEP are each separate electric utilities that are independently obligated to implement PURPA and to purchase the full output of QFs like Cherokee that commit to sell and deliver its power to DEC or DEP over a specified future term. This is important to understand in light of Cherokee's suggestion that it can sell its power under a PURPA contract to both DEC and DEP at the same time. Cherokee suggests that because of the Joint Dispatch Agreement, or JDA, between the companies and their common employees, Cherokee should be able to sell to both. I explained that the JDA enables DEC and DEP to transfer economic energy between their generation and use lower cost energy from one system to displace higher cost generation on the other system. Importantly, it does not enable the companies to operate as a single utility or facilitate joint capacity planning. In addition, the regulatory conditions associated with the Duke Progress merger expressly prohibit the companies from transferring any rights to generation or transmission facilities between them, or to construct facilities for the benefit of each other.
Thank you. And then on pages 19 through 21, you discuss the concept of a legally enforceable obligation, which has been an important issue discussed throughout this hearing and in the pre-filed testimony. Can you please summarize this portion of your testimony for the commission?
Yes. FERC's regulations implementing PURPA allow QFs to either sell power to a utility on an as-available basis or pursuant to a legally enforceable obligation at a forecasted avoided cost rate. QFs may contract to receive rates based on utilities' avoided costs calculated either at the time the power is delivered or at the time the QF makes a legally enforceable commitment to sell power over a future term. My testimony describes FERC's guidance that the non-contractual legally enforceable obligation concept is designed to protect the QF's right to sell power to the utility under PURPA, and that the establishment of a legally enforceable obligation turns on the QF's commitment rather than the utility's actions. I explained that a QF must make a real and binding commitment at the time it asserts a legally enforceable obligation in order to enable the utility to rely on the QF's capacity for the future term of the purchase contract. If a QF like Cherokee could walk away at any point in the process without actually obligating itself to the utility, then no legally enforceable commitment to sell power is created under such circumstances. I also explained that it is the role of this commission to determine whether and when a legally enforceable obligation is created in the absence of a mutually binding power purchase agreement.
Thank you. And based on your knowledge of FERC's rules and guidance regarding the concept of legally enforceable obligations, you testified that Cherokee did not establish a legally enforceable obligation with either DEC or DEP in late 2018. Can you explain your reasons for this position?
Yes. My testimony overviews the company's standardized process for negotiating a PPA with large QFs. This process is designed to result in a binding commercial arrangement in the form of a PPA between Duke and the large QF that essentially memorializes the QF's contractual commitment to commence delivering power to the utility for the specified term of the PPA, and to be paid the utility's avoided cost for its power. By committing to sell its power under a PPA, the QF is making a meaningful and enforceable commitment to sell power to DEC or DEP. Based on my review of the correspondence between Cherokee and the companies, Cherokee's actions did not demonstrate a legally enforceable commitment or obligation by the QF to sell its power to either DEC or DEP. Cherokee repeatedly rejected the company's avoided cost rates in form of PPA and made counter offers at rates well above the company's avoided cost. Cherokee also offered to sell its full output to DEP subsequent to offering to sell its full output to DEC, effectively terminating any offer to sell to DEC. I also highlight Cherokee's recent statements to FERC that upon expiration of its current PPA with DEC, it had the right to sell its power to third parties, demonstrates that no commitment was made. All of these actions show that Cherokee did not obligate itself to sell power to DEC or DEP in a legally enforceable manner. This lack of binding commitment prevented DEC or DEP from relying on the Cherokee facility to reliably and accurately plan to meet its system capacity needs after the current PPA term expired. Cherokee had the right to sign a PPA, but chose not to do so.
Thank you. And then on pages 26 through 28, you discussed the concept of a first year of projected capacity need. Can you please summarize that testimony for the commission?
Yes, I explained that purpose intent was that QF should be fairly and reasonably compensated for incremental capacity and energy costs, that but for the capacity and energy the QF provides, the utility would be forced to purchase or produce elsewhere. But if the purchase of a QF's output does not avoid the utility's need to incur incremental capacity and energy expenses, then the QF should not be compensated for providing that benefit. In other words, if the QF does not allow the utility to avoid capacity the utility would otherwise generate or procure from another source, there is no incremental capacity cost being avoided. I highlight that FERC has made this concept clear on multiple occasions, most recently in FERC Order Number 872. This commission also expressly recognized and adopted this concept in approving the company's avoided cost methodology in the 2019 avoided cost proceeding under Act 62. To effectuate this concept, the companies provide avoided capacity credits to QFs based on the actual capacity being avoided by the purchase of the QF's output, as reflected in the company's most recent IRPs.
Thank you. And then the last major sections of your testimony, you address transmission-related arguments presented by Cherokee. And on pages 29 through 33 of your testimony, you address Cherokee's arguments regarding its desire to wheel its output to Duke Energy Progress. Can you summarize that testimony for the commission?
Yes. The companies agree that under PURPA, a QF can sell its power either to the utility to which it's interconnected or to any other utility to which the QF can deliver its output. I agree with Cherokee that if it chose to will its power to DEP, it would have the right to request DEC to transmit and deliver Cherokee's output to DEP, or any other utility for that matter. And DEC would be required to provide this transmission service on a non-discriminatory basis under the company's Open Access Transmission Tariff, also known as an OAT. At that point, DEP would be required to purchase Cherokee's output at DEP's avoided cost. However, it's Cherokee's obligation to arrange for transmission service under the OAT to deliver its power output, the power out of DEC into DEP. My understanding is that Cherokee never took the necessary step of requesting this service. I also explained that if Cherokee has a dispute with DEC or DEP regarding transmission service, that is not a PURPA issue for this commission to decide, but rather is an issue that falls under FERC's jurisdiction over the company's implementation of its OAT.
Thank you. And then on pages 33 to 37, you discuss Cherokee's claim that it should be designated as a network resource and could deliver its output to either DEC or DEP. Can you summarize that testimony for the commission?
Sure. Similar to the wheeling issue I just discussed, the designation of network resources is addressed in the company's OAT and falls exclusively within FERC's jurisdiction. I also reiterate that DEC and DEP maintain, plan, and operate separate balancing authorities with separate network resources to serve their respective customers and do not jointly designate network resources. I explained that Cherokee's statements on this issue demonstrate a lack of understanding of the company's approach to network resources to provide firm, native load service to its customers and ignore the company's obligation to treat all QFs in a non-discriminatory manner.
Thank you, Ms. Bowman. Mr. Chairman, Ms. Bowman is available for cross-examination and questions from the commission.
Cross-examination.
Mr. Chairman, this is Bill DeGrandis. I'll conduct a cross-examination.
Please proceed, sir.
Good morning, Ms. Bowman. Thank you, Mr.
Good morning.
Chairman.
Good morning.
Good morning. Can you hear me all right?
I can.
Thank you. Ms. Bowman, I'm Bill DeGrandis. I'm co-counsel with Mr. Pringle and Ms. McGrath, representing Cherokee County Cogeneration Partners, LLC, in this proceeding. Now, my questions this morning regard some of your statements regarding PURPA. I note that we cite to some of the same sections of PURPA, but we seem to have come out to different conclusions. But my questions are designed to kind of clarify where we have similar views between Cherokee and Duke and where the parties have different ones. Now, you're employed by Duke Energy Carolinas, or DEC, as well as by Duke Energy Progress at DEP, correct? You're employed by both?
Well, I work for both. I'm technically employed by Duke Energy Carolinas, but I allocate my time to both utilities.
And you're Vice President of Regulatory Affairs and Policy for both DEC and DEP?
Yes, for both DEC and DEP in North Carolina.
And your testimony is submitted on behalf of both companies, correct?
Correct.
Now, we're all referring to the term LEO, so we're all on the same page. You're referring to a legally enforceable obligation under PURPA, correct?
That is correct.
And you recognize in your testimony, Ms. Bowman, that whether to submit a LEO is the QF's right, not the utilities, correct?
I do.
And you noted also that it's the QF's option to have its avoided cost rates based on either at the time the power is delivered or prior to the commencement of the term at the time the obligation is incurred, correct?
Yes, that's what I said in my summary and in my testimony.
Thank you. Now, I'd like to show you our first exhibit. It's a Duke response to Cherokee's second set of discovery responses, number 1. We've labeled it as Cherokee Bowman Exhibit number 1. And we'll put it up on the screen. There we go. Let's scroll down to the second page. Now, Ms. Bowman, your testimony actually is referenced at the end of this discovery response, correct?
Yes, it says see Kendall Bowman direct testimony at 19 through 21.
Great. And was this response prepared by you or someone under your supervision?
Yes, it was. Let's scroll
Now, the
back up. I need
response-
to make sure it's the right one,
Sure, I'm
if you
sorry.
don't mind.
I'm very sorry. Go ahead, take your time. We'll go after the first part, and let us know when you're ready to go to the second page. I'm sorry, we rushed through it a bit.
Okay, yeah, scroll down, please.
Okay.
Yeah.
So if you stop right there for a second,
Yes.
the
Okay.
lead in to the answer says the companies do not, and then contend that, et cetera. But let me know when you have a chance to see the rest of the top of the second page there, Ms. Bowman.
I see it.
Okay. Now, the response notes that the utility does not have a right to unilaterally revoke or nullify a QF's LEO, correct?
That's correct.
Okay. And the legally enforceable obligation or LEO can be contractual in the form of a PPA or non-contractual, correct?
That is correct.
Okay. And then ultimately, as your response notes in the last sentence, ultimately, it's this commission who determines whether a non-contractual LEO has been established, and that can be based on the QF's conduct and the utility's conduct. Isn't that correct?
That is correct. And if you look at FERC Order 69 and some of the case law that FERC has out there, this determining a non-contractual LEO can be a complicated issue, and no two states look at it the same way. And ultimately, it turns on the commitment and the obligations made by the QF to the utility. I think if the utility is not proffering up a PPA or an avoided cost, the QF can take that to the state commission, and then the state commission determines when that legally enforceable obligation occurs.
Very well. Thank you, Ms. Bowman. And we'll be looking at Order 6.9, sections that you've cited too as well in just a minute. But at this point, Mr. Chairman, I'd like to admit this discovery response into evidence. I'd like to admit Cherokee Bowman Exhibit Number 1 as the next hearing exhibit, which is this Duke discovery response that has this question Ms. Bowman about. It contains a helpful clarifications really of Duke's positions. So, Mr. Chairman, I'd like to admit this into evidence as the next hearing exhibit.
Cherokee Bowman Cross Exhibit 001 will be marked and entered into the record as hearing exhibit 18.
Thank you, Mr. Chairman. Okay, we'll go back. We'll move off the exhibit. Yeah, we can take the exhibit off the screen. Thank you. Now, Ms. Bowman, the rates under a LEO are projected or estimated based on the facts or data known at the time of the LEO, correct?
That is correct.
Okay. And these projected rates may end up being higher or even lower than the avoided cost time of delivery, correct?
That is true for any avoided cost rate.
Ms. Bowman, I'd like to refer you next to Cherokee Exhibit Number 3. We'll put that up on the screen. And as you testified, you've reviewed PURPA regulations, and especially those with regards to rates for purchases. So we'll put Cherokee Exhibit Number 2. No, there we go. There we go. For the record, I'm going to question Ms. Bowman about FERC PURPA Reg 292.304 titled Rates for Purchases. And we're going to scroll down a bit. Now, Ms. Bowman, you're familiar with this FERC reg. In fact, you cite to it in your testimony.
Yes, I am well familiar with 18 CFR.
We all are, I believe. Thank you. So let's scroll down a little more. Ms. Bowman, this is the 292.304B5, and I'm sure we both have been looking at this in preparation for the hearing, but just for the record, this shaded part 204.304B states that where purchases are based on estimates of avoided cost over the specific term of a contract or other LEO, the rates for purchases do not violate this subpart if the rates for such purchases differ from the avoided cost at the time of delivery. That's your view as well, correct?
Correct. And actually, this is one point that if you look at some of the South Carolina, this commission's orders, they want to have the most up-to-date when you're negotiating large QF contracts, as the case with Cherokee. You want to have the most up-to-date avoided cost rates at that point in time when you're negotiating those contracts, so as to not have potential overpayment to customers. And so, yes.
But if the rates the LEO, you look at the time period of when the LEOs, I know there's a dispute as to whether a LEO was established, but assuming there was, we use the estimated cost projections at the time of the LEO, correct?
That is correct.
Okay. Great. Now, Ms. Bowman, I'd like to, well, first of all, just take judicial notice for you, well, Mr. Chairman, of this. This is a FERC reg, but we'll just ask for judicial notice. We don't need to admit it as a hearing exhibit.
Notice taken.
Thank you. Thank you, Mr. Chairman. Now, we've both been talking about Order 6-9. And Order 6-9, that was the first final rule of FERC implementing PURPA, correct?
Well, I think there was a FERC order 69 and 70, but 69 is the main one.
Right. And you've cited the Order 6-9, and I'd like to show you an exhibit, which is labeled Cherokee Cross-Examination Exhibit, Bowman Exhibit number 4, which is an excerpt from Order number 6-9. Now let's go over to the right. Of course, it's Federal Register, so we have other things, but on the right side, this is the beginning part, it's Order 6-9, and I'm showing you, instead of the whole order, the excerpt regarding legally enforceable obligations. So let's scroll to that page, next page. There we go. Now, this moment, you actually cite to this page, you actually cite to the quote that we're going to talk about in a second in the third column. But this section of PURPA labeled, Order 6-9 labeled legally enforceable obligations, which is labeled at the top of that second column. You've reviewed this section of Order 6-9, correct?
I have.
Yeah. Now, let's look at, please take just a minute to look at the first shaded section that starts with some of the comments received. Please take a minute to look at that and let me know when you've had a chance to review it.
Okay.
Okay. Thank you, Ms. Bowman. So right from the very beginning, at the beginning of that quote, this is Order 6-9, FERC implementing PURPA for the first time. Right at the beginning, FERC's addressing this concern that of some commenters who say, wait a minute, there's a chance that the avoided cost of energy at the time the power is supplied is less than the price provided in the contract or under the obligation, the LEO. So this concern was raised right from the beginning with FERC, correct?
That is correct.
FERC says, well, we recognize that possibility. I'm looking at the middle here. But we're cognizant that in other cases, the required rate could turn out to be lower than the avoided cost at the time of purchase. And then the commission goes on to say, we don't need to have to line up minute by minute the contract or LEO rates with the rates at the time of delivery. Is that fair characterization, Ms. Bowman?
It is, but we can't just read this and not take it into context. I think this is why, the South Carolina Commission and the North Carolina Commission update avoided cost rates every 2 years. And while they also encourage the utilities when they're doing large negotiations with QFs to use the most current avoided cost fuel cases when they're establishing those rates. The whole point behind PURPA and these federal regs is there's this cooperative federalism where a lot of the discretion is put at the state level to determine what is best for each state. Every rate you create, if it is a fixed rate, the minute you sign that contract, that rate potentially could be higher or lower than the next minute. So that's why states do this every few years review of those avoided cost rates.
Mr. Chairman, may I ask that the exhibit be enlarged on the screen a little bit? I'm having difficulty reading.
Sorry, certainly. Mr. Commissioner, let me know if is that acceptable? Great, thank you, Mr. Commissioner.
It's good for me, but I don't know. Vice Chair Belzer?
I'm concerned about our virtual commissioners. If they could give us a thumbs up, it would help.
Can everyone see it okay?
I think that helped. Thank you.
Yes, sir. Go ahead.
Okay. Thank you. Thank you, Mr. Chairman. Now, Ms. Bowman, this next shaded section, you've cited to this exact quote at pages 19 to 20 of your testimony, right? And this is where FERC says, look, we've heard all these concerns where the rates at the time of delivery could be different than the rates that were projected or estimated at the time of the contract or at the time of the LEO. But they come back and say, use of the term legally enforceable obligation is intended to prevent a utility from circumventing the requirement that provides capacity credit for eligible QF merely by refusing to enter into a contract with the QF. Now, you cited
Yes.
this exact quote, Ms. Bowman, in your testimony, correct?
I absolutely did, and I think it is it is a true statement. And we provided Cherokee with a PPA and an avoided cost rate. And if they disagreed, they had the ability to take it to the South Carolina Commission, as they have done now.
Yes, Ms. Bowman. Now, let me ask, now I know you weren't involved in negotiations, and if I ask you a question specifically that are not with your knowledge, please let me know. But I think you've been here at the hearings the last couple days.
I have, yes.
Okay. So let me make a couple observations, and then I'm going to link it back to a question to you. Mr. Freund testified yesterday that after Duke provided in October 2018 its avoided cost rate and a form PPA that wasn't dispatchable, was a must run. But after that time, the subsequent offers that he testified about were based on current, it wasn't further information about the rates projected at the time of the September 2018 LEO from Cherokee. Do you recall that? That's Mr. Freund?
Yes, I recall that testimony.
Okay. And Mr. Snyder said yesterday, oh, I don't think Cherokee had a LEO from the beginning. But do you recall him saying that?
I do.
Okay. Now, there was also testimony by Mr. Keene during the cross-examination by Mr. Pringle for Cherokee about Duke's October 5, 2018 letter to Cherokee, which was responding to Cherokee's September 17 letter, where Cherokee submitted its notice of commitment for a LEO. I have a couple questions about that. We'd be glad to put that letter on the screen. I have just very high-level questions for you about that.
Okay.
Okay, so let's scroll down. Right there, let's stop. This is early on in the process, just less than 1 month, just a few weeks after Cherokee submitted its September 17 notice of a commitment and its LEO. where Mr. Keene says, DEC does not agree that the September 17 letter or the accompanying notice of commitment establishes a legally enforceable obligation or LEO under PURPA. Now, he goes on to say, notwithstanding that, we will send, he didn't have available at the time, but they sent later the avoided cost rate sheet and the must-run contract. That was later in October. But I'm just focusing on this statement. Does Mr. Keene, as a business development manager, have the corporate authority to advise a QF that what the QF submitted and asserted to be a LEO is not a LEO? Does he have the authority without getting authority from someone like yourself, who's a vice president of regulatory affairs?
If I recall, I believe Mr. Keene said that he consulted with regulatory legal in preparing his responses back to Cherokee.
But as vice president of regulatory affairs, let me back up a step. Given what FERC just said about the importance of a LEO, over the objections of people saying, wait a minute, when you lock in a rate, it could be very different than the rate at the time of delivery. Given the importance of the LEO, shouldn't the communication to that what you assert to be a LEO, we disagree, be run by someone at your position?
So I don't think a letter of intent establishes a commitment and an obligation. And I believe that, signing of a contract or really serious negotiations is conduct that signifies a commitment and an obligation. The letter that Cherokee sent signified an intent to sell. And then 3 weeks later, they submitted in an RFP for DEP. And then a couple of months later, they submitted a very similar letter claiming a LEO to DEP. Their conduct does not suggest a commitment. And I do not believe just a letter alone. A letter is definitely intent, but it's not commitment and an obligation.
And you're aware that Cherokee asked, if you need any other information from us, please provide it.
Yes, and I believe their letter also asked if, I don't know if you have access to it, for the companies to agree whether or not they thought that what they provided sufficed as a legally enforceable obligation. And what we have here on the screen signifies to Cherokee that we're not in agreement that it's a legally enforceable obligation.
So Duke decided within several weeks of the submission of the notice of commitment from Cherokee that you don't have a LEO here. Now, the state commission, as you pointed out, is the ultimate decider, but the commission can look at, as you pointed out, the QF's action, but as you pointed out in your discovery response, they also can look at the utilities actions, correct?
Yes, the commission can look at both parties' actions, but I think the establishment of the LEO turns on the fact that if the QF is committed and obligated so that the utilities can count on that capacity and energy in planning its system. It is the integrated utilities' ultimate statutory obligation to provide affordable and reliable electric service to our customers. And we have got to be able to plan and count on that capacity and energy in order to do so.
Right. So we have a dispute as to whether that LEO was established, but I'm focusing on what the commission can review in the context of this proceeding to determine whether a LEO was established. And you've testified in your Duke response said that you can look at the QF's actions. You can also look at the utilities actions. So I'm going to focus more on the utilities actions at this point. So it just seems early on, DEC says, no, you don't have a LEO. Mr. Freund said any subsequent requests to me to do avoided cost rates were all current rates, not based projected at the time of the LEO. So it seems like Duke early on said this isn't a LEO, and every step they took thereafter was to send them current rates. And that's really rates based on time of delivery, not based projected at the time of our LEO. Isn't that true?
No, I think I disagree. I think we did not believe a Leo had been established. And as I look at the facts, again, I was not involved in any of this, but as I look at the facts, the offers that were sent to Cherokee, and again, I think it's clear by the facts that the Duke utilities were working hard to try to work with Cherokee by offering so many different versions. In my looking at these documents, what we sent over were contracts and rates at that point in time, not necessarily looking for when ultimate delivery would occur, but where the avoided cost rates were using the current avoided cost methodology, the same standard process that we use for all large QFs, using that methodology to try to offer a rate that Cherokee could accept. We were still in disagreement on when the Leo actually was occurring, but we were trying to work with Cherokee all along.
But the subsequent rates, and again, to the extent I'm asking a question, I know Mr. Keene was cross-examined extensively by Mr. Pringle on the correspondence. And I know you weren't involved back then, but I just want to hit some of this high level. There was no subsequent, as far as rate proposal sent, no subsequent, here's more information on the rate sheet that we sent in October 1 in response to your notice of commitment. We saw nothing else from Duke providing any support for the rate sheet that we got on October 31 from Duke. Are you aware of any?
I mean,
I'm talking
that's
about the projected rates at the time, at October 3rd. I'm not talking about the backup for the current rates. I'm talking about the as delivered. I'm talking about the projected rate at the time of the notice of commitment and the October 31 letter back from Mr. Keene to Duke saying, here's the rate.
that is a question better asked to witnesses Keene and Freund, not me. I was, I'm here just as, policy witness.
And Ms. Bowman, please, at any time I ask you questions, that's a perfectly reasonable response. I appreciate that. Now, you say that each company has its own IRP, but nothing prevents DEC or DEP from agreeing, hey, we got this plant, it's been running all these years, 2 decades, it's dispatchable, unlike these other intermittent resources that only run if the sun's shining or the wind's blowing. This is dispatchable. There's nothing preventing the Duke companies, notwithstanding that they have separate IRPs, from agreeing, why don't you take 50% of it and I'll take 50% of it. There's nothing preventing that, is there?
No, there's nothing that prevents that. But there was at no point, at least in the documents that I reviewed, that was really contemplated.
Well, the offers, again, stop me if you're not aware of them, but the notice of commitments, I think you did review, were sent to both DEC and DEP at the same time. So there wasn't DEC saying, here's a proposal, DEC, but don't you dare show it to DEP, or here's a letter to DEP, don't you dare show it to DEC. It was sent openly, transparently to both, so that the companies could coordinate if they choose to, correct?
That is correct, but I think we need to kind of step back. In order, this asset sits in DEC's balancing authority area. In order for DEP to take all or any part of that energy and capacity, there must be a firm transmission path established out of DEC, delivering it to DEP so that you can actually get the energy and capacity to the DEP balancing authority area. My understanding of the facts in this case was there was no transmission service request submitted by Cherokee to the DEC transmission, to OAT, via open access transmission tariff. So you have to establish that before DEP can be a part of this equation.
But if DEP said, hey, we're interested, and, this facility's been running all this time. Let's work out the details. We'll work out the delivery details, because you're right, the plant's in DEC, we got to get the power to DEP. So if the companies got together and said, let's share this capacity, then those details can be worked out. Okay, DEC, we're already connected. DEP's, we got to get the power. That those details can be worked out, but we didn't see anything in the correspondence back to us that the companies were willing to coordinate and each purchase a portion of the output. There's nothing that you saw, correct?
I believe this line of questioning is more appropriate for witness Snyder in terms of he handles the resource planning of our system. Under PURPA, a QF can request that the utility it's interconnected to send that power to another utility, i.e. DEC. They could have requested DEC send that power to DEP if they're doing this pursuant to PURPA as a QF. Now, they are also entitled, Cherokee is also entitled to sell power, in the wholesale market and not do it under PURPA, of which, in this case, there are facts that show that Cherokee did submit a bid into DEP's RFP as a need for capacity. But again, this line of question is more appropriate for witness Snyder.
I understand, Ms. Bowman. Ms. Bowman, that concludes my questions. Mr. Chairman, that concludes my cross-examination of Ms. Bowman. Ms. Bowman, thank you very much for your time this morning.
Office
Thank
of
you.
Regulatory Staff.
ORS has no questions for this witness. Thank you, Mr. Chairman.
Commissioner questions for Ms. Bowman.
Mr. Chairman,
Vice Chair Belzer.
thank you. Good morning, Ms. Bowman. It's been a number of years.
It has. It's good to see you again, Commissioner Belzer.
It's good to see you too. Ms. Bowman, can you give me any FERC opinions or case precedent that support Duke's argument that there was no LEO established in September 2018?
So I can give you a cite to, well, we've talked about FERC Order 69. And so I think that has some precedent in there. Also, there is a case, FLS case, I believe in 2016, that talks about it turns on the QF's commitment. They've got to be committed and obligate their power and their energy and capacity so that the utility can plan the system. So there are cases out there. And as I said earlier, this PURPA is, kind of that cooperative federalism,
Right.
where each state can implement as they see fit.
Okay. And North Carolina had a proceeding where North Carolina promulgated a regulation or a directive on what North Carolina required for the establishment of a LEO. Is that correct?
That is correct.
South Carolina's not had such a proceeding that you're aware of. Is that correct?
Not that I'm aware of. I believe there is a notice of commitment form for small QFs in South Carolina, but the NOC form.
Okay, but we don't have one for large QFs.
Not that I'm aware of.
Okay. And so if a large QF in trying to or purporting to establish a LEO uses the wrong form, is it Duke's position that that's just not acceptable and is not a commitment, is not, or I think your term was committing and obligating to provide that power and capacity?
That's our current methodology right now is, for the large QFs, it is really a commitment, serious negotiations, not just a letter or an email.
Okay, so somebody submits a letter, an email, or even uses the wrong form.
Vice Chair Belzer, I'm sorry to interrupt you. We are experiencing some background noise. If you're not speaking, could you please mute your microphone? Thank you.
Thank you, Mr. Chairman. Ms. Bowman, if a large QF sends an email or a letter or the wrong form, what does Duke consider that the beginning of negotiations or not?
Well, I think there's a difference between the beginning of negotiations and serious commitment. But I believe, it's ultimately up to this commission to determine if there is not a meeting of minds of the parties on terms of when an LEO is established. It's up to this commission to determine such.
And that term meeting of minds of the parties, that's basic contract law. Is that stated in PURPA?
No, that's not. That was my terminology. I apologize.
No, that's fine. I just want to be clear here. Now, somewhere in your questioning, cross-examination, I wrote down a phrase that you said, the signing of a contract signifies an obligation. Do you recall a response to that effect?
Yes.
Okay. So is it Duke's position that a QF must sign a contract to create the LEO?
I think at that point in time, it's indisputable. Once they've signed the contract, then they've definitely committed and obligated.
Are you aware of FERC decisions that say the contrary of that it does not take the signing of a contract or an interconnection agreement or the PPA or an interconnection agreement to create a LEO? That the FERC has found states states requiring the signing of a PPA or an interconnection agreement to be contrary to PURPA for purposes of creating a LEO.
I don't know that I have canvassed all of the FERC cases. I think more often than not, FERC has deferred to the discretion of the states. I think there are some states that require a signed contract in order for a LEO to be created. I think there's some states that have created forms that once you establish that form, a LEO is created. So I think it differs from state to state. There is a lot of case law out there on this in different jurisdictions.
Is it Duke's position that a PPA or contract must be signed prior to a LEO being formed?
My understanding, and I don't deal in the PPAs and QFs and the commitments all the time, but my understanding is when we're negotiating large QF PPAs, that if there's serious negotiations, looking at the conduct of the QF, they're seriously, they're committed. They're dedicating that capacity and resource to us. I think if there's serious negotiations going on, we would support the establishment of the LEO at that point in time. As we look to this case, the conduct of Cherokee was confusing at best in terms of whether they were committing that capacity and energy to DEC in September of 2018. I think you've heard testimony that shortly after that letter saying they were committing, they also submitted a bid in the DEP RFP. And then that was even before we had responded to them with our PPA and avoided cost rates from that September 17th letter. And then they turned around and submitted a commitment letter, not a commitment letter, a letter of intent to DEP in December. And then there were some other FERC proceedings going on. I think I referenced a recent FERC filing where Cherokee stated that they could sell to any third-party entity. I think it was confusing at best for the utilities looking at the facts of this case.
Okay, and I don't disagree with some of that, but is there any requirement for the utility to have communications with the party to try to sort out some of that confusion? Or is it all on the QF to contact the utility?
I think the utility tries to work with each of the QFs. I do believe there is no bright line rule either that the commission has established or that the utilities have used when establishing a LEO for large QFs. So I think there is perhaps some clarity that's needed. So I think every case is kind of different. We try to treat all QFs consistently. So as just as we offered up the 5-year avoided cost rate, we were doing that with all large QFs, as other witnesses have said.
Okay. And looking at the wrong page here. And if a QF doesn't like the avoided cost rate that is tendered by the utility, does the utility provide documentation to show how that avoided cost rate was calculated and that is the appropriate rate for QFs at that time?
Yes, I believe we share the methodology for how we're calculating the rates and the inputs in that. I don't, that question's probably better answered by witness Freund. I know we responded, and we are to provide the methodology, and we use the consistent methodology.
Okay.
For large QFs, you want to have the most current avoided cost rate, as we described before. So you're updating kind of fuel numbers and numbers that change frequently. But I do believe that the companies, responded. It appears there's disagreement in terms of, was there enough information there? I don't know. That would be better answered by another witness.
Okay, fair enough. And I had something else marked. Find the page. And the QF, isn't it up to the QF to determine? Well, if there is a LEO formed, let's presume there's a LEO formed. Isn't it up to the QF to determine before? Is it before the contract is signed or before power is delivered whether to accept the avoided cost at the time of the LEO or the avoided cost at the time of delivery?
It is the QF's decision to accept it at the time of delivery or at whatever point in time you create the LEO.
But when must that option or selection be made? Is it at the time of the PPA being signed, or at the time right before, or the beginning of the contract?
I think it's at the beginning of the contract. If you look at CFR 18-292-304, I think the one we just had up that Attorney DeGrandis showed up, it's the QF to make that determination at the get-go. Do they want to go ahead and create a legally enforceable obligation at some future point in time? Or do they want to just get the avoided cost rate at the time their power is delivered? So I think that is at the beginning. Before they create a LEO, I think the QF makes that determination.
You may not be I just want Duke's position on this, and if you can answer it, I'd appreciate it. But what exactly did Cherokee fail to do in Duke's, or did Duke find that Cherokee failed to do to satisfy establishing a LEO in September?
So
of 2018, excuse me.
So I would just give you my opinion, but it might be better answered by witness Keene or another witness. we responded with that initial intent letter from Cherokee that we did not believe that established the LEO at that point in time. I believe had we gotten into serious negotiations and Cherokee did not submit a bid into the DEP RFE, that might have signaled their commitment, their true commitment that they were wanting to pursue. Obviously you negotiate the T's and the C's, the terms and conditions of the PPA, and that could take some time. I think that's why we referenced kind of the 60 days. You want to have, when you're negotiating these large contracts, the most up-to-date rates for the benefit of the customers, because ultimately these costs flow through to the customers. So I think a commitment of some serious negotiation there would be my opinion.
Okay, and I recall in your response earlier that there was confusion because of getting an email in September and then bidding into a DEP project and then an email to DEP saying we want to commit this energy to DEP after learning that DEP or DEP had a capacity need earlier than DEC. So we get to 2019 and activities in 2019. And even in those negotiations, Duke takes the position that no LEO was formed. Is that correct? Maybe not negotiations, but with those correspondence for the same type failures?
For the same type of, there was no true commitment or obligation, no real serious negotiations at that point in time.
Okay. Now, I reckon I'm a little confused by Duke's not confused. I understand that it's Duke's position. They put a 60-day acceptance of the rates on in these letters so that the rates aren't stale. Is that correct?
Correct.
But if a LEO is formed, the QF under PURPA regs has the option to choose those rates at the date of the LEO was formed. Is that not correct?
That is correct.
Is that
if it's established, if it's confirmed, then yes, they have that right.
Okay. Just want to be clear on that. Ms. Bowman, thank you for your testimony and expertise today. It's good to see you again, and I appreciate you answering my questions. Thank you.
Thank you.
Commissioner questions for Ms. Bowman.
Mr. Chairman?
Is that Commissioner Urban?
Yes, sir.
Commissioner Urban, you have the floor, sir.
Thank you. Good morning, Ms. Bowman. How are you today?
Good morning, doing good.
This case really is kind of an interesting question, and maybe one a law student might encounter on a law school exam. But I'm wondering, based on the testimony that we heard yesterday, I believe it's from Mr. Snyder, the fact of the matter is that if South Carolina Public Service Commission concluded and found that a LEO was created in 2018, Cherokee would not benefit in terms of their monetary contractual rights because the avoided cost rates were lower than more recently. Isn't that correct?
I believe that is what witness Snyder testified to yesterday.
Right. And so as witness Snyder told us, Duke Energy Carolinas has extended a higher avoided cost rate, which was updated to 2021. And therefore, Cherokee would be punished in a sense monetarily if we found that a LEO was created in 2018, at least from a monetary standpoint. Would you agree?
I would agree based on what I heard witness Snyder say yesterday. Yes, sir.
All right. So it really becomes an academic discussion at this point because one would think that Cherokee would want the higher rate in its PPA. You agree?
Agree.
And to make matters better for Cherokee, witness Snyder indicated that the company would even allow Cherokee to spread the overpayment over the 10-year term of the PPA, which will save them upfront costs should they have to go out in August and purchase or pay for a letter of credit. True?
I think that's what witness Snyder said yesterday.
And we know there'll have to be a true up, and I think we'll hear from the Office of Regulatory Staff witnesses later that in fairness to the ratepayers, a true up is required. Would you agree with that? Because if there's no true up, the ratepayers will have overpaid for that dispatchable energy generation as a result of our previous order, which extended the prior contract. True?
I don't know that I'm the right witness to answer that
Right.
question.
Right. Well, Mr. Snyder was of that opinion. Anyway, so my point being that I think perhaps Cherokee might want to rethink their position on insisting that Leo was formed in 2018 because it really works to their monetary disadvantage for the company, given the facts that we have. Would you agree?
I would agree based on witness Snyder's testimony.
Thank you, ma'am. No further questions.
Thank you.
Commissioner Caston.
Thank you, Chairman Williams. Good morning, Ms. Bowen.
Good morning.
This is really kind of neat, a non-attorney questioning an attorney.
I'm a recovering attorney. I'm not practicing anymore.
I understand. To kind of, well, I wouldn't say build on what Vice Chair Belser had, because she is an attorney and she asks questions quite well. But something that I've struggled with through this whole process, trying to understand if it can be understood, is in this whole real issue. And certainly I do think that's the issue. Was it? And if it was, when did it occur? And if it isn't, why is it not? Which is what all this discussion's been about, I think. But what's troubling me, if there is an existing contract, for example, Cherokee and DEC has an existing contract. I think it's 10-year, whatever the period. Is there an acceptable period a QF may establish a LEO during the contract period? For example, and I think I've used this example before, if there's a 10-year contract, and I keep hearing this stake in the ground, if the QF sticks a stake in the ground, that is the starting point. You know, boarding cost, whatever. So if there is a, say, 10-year contract, and let's say a QF believes that, you know, based on things I'm seeing, the avoided cost may go down by year 7 or 8. I'm going to stick that stake in the ground in year 3 of my 10-year contract. Is that acceptable?
Well, I think they could reach out and say legally enforceable. I'm setting my legally enforceable obligation. I am committing to sell to you at the expiration of my current contract. I don't know what the contract says. That seems to kind of, you know, if you've got a 10-year contract and then in year 3 you're setting a stake in the ground to try to lock in higher avoided cost rates. I don't know that that's in the best interest of customers. And I think PURPA is clear that it is not to harm customers. It's supposed to be reasonable and just and fair to customers and the QF. And I think locking in that early on would be unfair to customers.
I'm not certainly arguing the merits one way or the other. I guess that's what I'm struggling to understand. Is there anything in purple regs, FERC, or whatever that kind of addresses that? Because the way it
I'm not
seems-
aware of I'm not saying there's not out there. I'm not familiar with a case that hits on point with your hypothetical.
Well, it is hypothetical, but best I can determine, it can be realistic. Apparently, there seem to be no rules for that. Is that a fair statement? Or you're not aware of that?
I am not aware. The FERC regs say that it turns to the states to really make the determination on legally enforceable obligations. The regs give that optionality to the QFs, but in determining, if there is a dispute, like what we have at the current moment, if there is a dispute on when the LEO is established, it turns to the state commissions.
Okay. And I think it was Order 69. I think that's what Mr. DeGrandis had on the screen. And I was one of
Yes.
those kind of struggling to read it also. And I did try to read the highlighted part. For the non-attorney, as I read that highlighted part, is that just editorial, or do those words that were highlighted all have legal standing, or they're the gospel according to?
Yes, they are in the code of regulations.
So, and I'm not, words mean things to me. And especially when I read such as that, I try to is that an editorial comment, or what does that mean? And I noticed in that one of those highlighted sections, it says commission does not believe, and there was some words before that and after that it's intended to require minute by minute evaluation of cost.
Yeah, that is a summary. That's not in the actual regs. Yes. I think what we had up on the screen was a summary.
That's what I needed. Thank you. And if I understood you correctly earlier in your, I think, testimony, you, I think, stated that you did not think, or the Duke companies did not think it was a commitment of by the QF if you can board or walk away from it, it's not a LEO. At what point was there verbiage from Cherokee that Duke interpreted that they could board it or walk away from it, or it was not a commitment? The September 18th letter? When was that established?
So I believe witness Keene sent a letter to Cherokee, and I think Attorney DeGrandis showed that on the screen, where the Duke Energy Company's DEC responded and said they did not believe the letter they sent created the legally enforceable obligation. And I believe witness Keene sent a similar letter in response to the Cherokee DEP letter of intent to commit to DEP. I believe Witness Keene sent a similar letter explaining that at that point in time, Duke Energy did not believe LEO had actually been established.
Well, that part's been, well, I wouldn't say clear, but that's obviously been the argument. And also, if I understood your testimony, another reason you and the Duke companies believe it is not a legally enforceable obligation was because they committed the same capacity or whatever, or capacity to two different utilities. Is that correct?
That's correct. Cherokee consistently walked away and looked for other options to sell its power. No fault. I think they were probably trying to find the highest price they could get for their power, but clearly that signals a lack of a commitment.
Understand? Well, this is when I wish I had a little more law degree background so I could ask things or request things like maybe legal briefings from both sides or whatever, but I'll leave that up to hopefully one of our attorney PSC members, and perhaps they could do that. Thank you.
You're welcome.
All right. Ms. Bowman, I have a couple of questions for you.
Okay.
I hate to oversimplify things, but I try to keep life simple and shoot straight, not to complicate things more than necessary. And when I look at this case, I consider that we've been in this hearing. It's Friday. When did we start on Monday? We've been in this hearing since Monday, listening to testimony regarding when or whether a LEO was established. And there's been some accusations of bad faith and so forth and so on. And what I haven't seen, again, I hate to oversimplify things. I haven't seen, and maybe I missed it, a demand letter. That's what I'm going to call it. A demand letter from Cherokee that essentially says, we are ready to offer our services to you, offer your energy needs to you. At this moment, we're ready to enter into a PPA, and this is the date that we believe that our LEO is established, and we're putting our stake in the ground today. We're ready to enter the contract. Is anything like that in the record?
No, I have not seen anything like that in the record. The letters that Cherokee sent never presented a binding commitment to sell. They never drew that stake in the ground. And
so, my background is not utility law. It's not utility law. And another thing I can't understand, and maybe you can help me understand, if I had millions of dollars on the line for a client, and it was important to protect my interest, if you will, as soon as I realized that the party that I was negotiating with was not moving their position, or they have stated their position, and was clear that they did not intend to move from that position, I would seek a decision from whoever the authority is. In this case, the Public Service Commission. So I'm having a hard time understand why in the world would Cherokee wait until a month before their contract is set to expire to seek some type of outcome from this commission. Can you help me understand that? I know you're not a Cherokee witness, but you are a recovering lawyer, and I'm sure you've tried some cases, and I'm sure you have experience in this area. I'm just trying to get your opinion on those facts.
It's going to just purely be an opinion. I don't know why they took so long. I mean, clearly under PURPA, a LEO can be a contractual commitment. you've executed the PPA, it's there, or a non-contractual, but still legally enforceable obligation where you can get a state commission to determine that the utility imposed barriers for whatever reason of a QF forming a contract or establishing a contractual commitment to sell. So, one would think that if they were very serious at the time we responded that no, you've not created an LEO, that they would have pulled the trigger to file something with this commission. I can only guess that perhaps they were hoping to get the highest rate possible, and that's why it took so long. I don't know. That's my best guess, is they were trying to find the better rate.
See, and that's what it seems like to me. And I don't, you never want to make accusations that are not supported by facts. You never just want to, in my opinion, you don't want to do that. But I'm just getting the feeling that there's a little bit of gamesmanship going on, essentially gaming the system for your benefit or for their benefit. That's the way it feels. I could be wrong. We still have more testimony to hear. But is that a practice of QFs in this arena to use the law? And granted, it's nothing illegal about it. So I'm not trying to say anyone is operating unethically or unprofessionally, or not operating in good faith. But it is what it is. In your experience, have you seen QFs attempt to, what I'm describing as, game the system for their benefit to get the highest price available?
Well, absolutely. I mean, and what for-profit entity wouldn't try to get the best rate available? We actually saw in FERC order, the recent order, FERC order 872, some further guidance on establishing LEOs for new QF resources. And it was out there to prevent sort of the gaming of the system for those facilities that might not actually ever get constructed, were claiming legally enforceable obligations. And so in FERC order 872, they said that these QFs have got to prove that these facilities are actually going to get constructed. So there has been gaming of the rules out there in the QF space.
And if the customers were not captive to DEC and DEP, and the costs were not passed on to them, and they have no right to refuse DEC or DEP service unless they're providing their own energy in some way, shape, or form, or they're just off the grid. It's very concerning that a QF would essentially game the system to their benefit, which, and I could be wrong, but it almost, help me if I'm wrong, correct me if I'm wrong, it almost seems like it would be to the ratepayer's detriment.
Well, it could be, because ultimately it is the ratepayers. This is a pass-through cost. So, the utility is required by federal law to purchase the output of these facilities, and it does get passed on to customers. And if there's gaming or, significant overpayment, then that ultimately flows through and burdens the customers.
Well, what's interesting is that we get to decide. So the commission, you've said it and others have said it, ultimately we get to decide, the Public Service Commission, based on the conduct, the actions and conduct of the utility and the QF, as to whether or not a LEO was formed. That's correct, right? It's up to us.
That is correct.
And the way we decide that matter may be different than the way North Carolina decides that matter, the way Georgia decides that matter, or any other state. Is that a fair statement?
That is correct. I believe, in FERC regs and subsequent decisions, each state has unique circumstances, and as long as they're adhering to the intent of PURPA, they can take it in, whatever manner they see fit.
All right. Thank you, ma'am, for your answers. Any more questions for this witness?
Chairman Williams.
Commissioner Williams, you have the floor, ma'am.
Thank you. Thank you, Ms. Bowman. I appreciate how long you've been on the stand, and I only have one question. I am curious if there's any legal precedent or decisions that would help us understand if the avoided cost must be agreed on prior to a LEO being formed. Does that question make sense?
I think it does. I think you're asking, does the actual rate have to be agreed upon to establish a LEO? I do not believe a rate actually has to be agreed upon. I don't know if there is a specific case on point. I don't know if you'd like us to do some research and follow back up, but nothing comes to the top of my mind, put it that way.
Thank you very much. No more questions.
All right. Any more questions for this witness?
Mr. Chairman.
Commissioner
Still
Powers. Commissioner Powers, you have the floor, sir.
Thank you very much. Ms. Bowman, good morning, or is it afternoon yet? It's right on it. I want your permission to steal your term, recovering attorney, because now that I'm on the commission, I feel like I'm one too. Is that okay?
That's fine.
Even more spectacular for me after being self-employed for many years is I come in and someone else has emptied my trash can and I don't have to do it. And that's just a wonderful feeling. I'm kind of following up on what the chairman asked you and would like, some simplification. One thing, is it fair to say that some of the FERC regulations and in the past and have been updated because of this reason, because they were vague in places and hard to put a direct answer to?
That is correct. I think one of the primary reasons for the recent FERC Order 872 was, the recent surge in renewable resources on the system. The hundreds of new solar facilities out there, and there were a lot of things that needed to be clarified, and I think that's what FERC was trying to do.
And you think it's better now and easier to deal with?
I think in some respects, yes, things have been clarified, but in others, there's still lots of areas of openings and room for interpretation.
Yeah. I realize that you represent DEC and DEP. And do you understand that with some offers being made to one company and then the other, how that is a bit confusing for us?
Yes, I can completely understand.
Well, I want you to put your lawyer cap back on for a minute and pretend you're my lawyer. If we find there's a LEO, what do you think is the avoided cost or the time of avoided cost we should use?
Well, if you decide that Cherokees established their LEO in 2018, is that what you're asking?
If we decided that, would it be the 2018 number that we would be using?
Yes, if you decided that they did indeed establish a LEO in 2018, the avoided cost rate would be in 2018, based on 2018 methodology.
And if we decided they didn't have a LEO and wanted to enter into a contract at this time, or based on, I guess it would be January 2021, what would be the avoided cost rate that would be used for that, in your opinion?
Well, if this commission determines a LEO is established in January of 2021, then that would be the avoided cost rate that would be used in calculating that.
Okay. Well, the only other choice would be no LEO, and that there's going to be a purchase power agreement entered into, and that number could be negotiable. Or is that number, as I've heard over and over, you're stuck with avoided costs and there is no negotiation as to that?
Well, you have to be, it cannot be above avoided cost. I think methodologies and all of that, it sounds like have been debated. But if they're going to be putting to us as a QF, then that rate must be based in, no higher than the company's avoided cost. They have the ability, if they want to just negotiate in a wholesale transaction, non-PERPA, that rate could be something completely different. But realize the companies, we're subject to least cost and have to provide, reasonable and affordable cost to our customers. So we're going to be looking for the best rate, to buy power at the best rate out there for our customers.
Commissioner Irvin may have touched on it, and there's been some testimony back and forth about possible reimbursement. I think one number that came up was just for this year, $6 to $9 million could be owed, or some total amount. If it was determined that money was to be repaid to go to the ratepayers, with your experience, how would that be done? Obviously, I don't know many people or companies that could just write a check for the total amount. Are those sort of repayments structured or over time, or how would that be done?
I believe it could be done a number of different ways. If you're talking about how Cherokee would refund to the utility, or if you're asking about how the utility ultimately would refund it to the customers.
Well, obviously the customers who we're concerned with, and I know you would have your procedure to do it, but how would Cherokee do it? And you say there's several different ways. What's the preferred way, or what's the normal way? I hate to use that word, but historically, what is the way it would have been done?
I don't know that I have dealt with a situation where we've had a QF actually submit a refund. I think you could either do it in one lump sum, or, if that financially harms that entity, maybe you do a sum every month for, a period of years. I think that could work either way. But I'm not familiar with a scenario where we've done this before.
Would that determination, if it happened, would that be under our purview for us to decide? Would we have that authority, or is that something that once we issue an opinion that the companies and Cherokee would have to decide?
I think this commission could make that determination if it so determines that Cherokee needs to refund customers.
Okay. Thank you very much for your testimony.
You're welcome.
Any more commissioner questions for this witness? Ms. Bowman, I do have one final question for you. Do you think the commission is at risk of setting a precedent if we find, whether we find a LEO existed or not? It's very possible that our decision will have implications on other situations in the future that are similar to this issue. Wouldn't you agree?
It could definitely be cited for sure, but you could make a determination based on the specific facts of this case, that each case are very fact specific.
Mm-hmm, mm-hmm. All right. Any redirect? Okay, hearing none.
Mr. Chairman, I do have a few questions and I recognize we're at noon, so I'll try to be fairly quick, but I think the commission's raised a couple important points that I'd like to just get the opportunity to clarify with Ms. Bowman.
Go right ahead.
First, thank you, sir. Ms. Bowman, thank you for your testimony today, and it's refreshing to be back with a recovering attorney versus in the weeds of the rates and charges like we were yesterday with Mr. Freund and Mr. Snyder. So I do have a couple questions about PERPA policy and some of the questions that you got from the commission as well as from Mr. DeGrandis. So first I want to start with your response to Chairman Williams and kind of what the the task before the commission here is in this case, and I think he framed it as the commission gets to decide when the LEO is established and what the rates are to be paid to Cherokee. That's generally the questions before the commission at this time based on this complaint proceeding. Would you agree with that?
Yes,
Okay. And that's informed by the purple regulations that you cite in your testimony. Is that right?
that's correct.
Right. And this is, you went through this regulation with Mr. DeGrandis earlier, and let me know if I can make it bigger on the screen here, but this is the 292-304 regulation. And just a couple key points that I think informs your response, but this subsection A is the rates for purchase, and this is kind of the parameters the commission has to apply in calculating the rates to be paid to Cherokee. Is that right?
That is correct.
Okay, and so the key objective here is that, and looking at sub 2, it can't be discriminatory against Cherokee, but kind of priority 1 is it has to be just and reasonable to the electric customers. And then I think you said this earlier, but this is what the regulation says, that nothing in these regulations can require the utility to pay any more than the avoided cost for purchases from a QF. Is that the kind of the core principles of the setting the avoided cost rates?
They are, and that's what I testified to earlier.
Okay, and so when you were speaking with Mr. DeGrandis and he was talking about another section, B5, that talks about the overpayments, this section about rates for purchases based on estimates over a legally enforceable obligation. I apologize, this kind of cuts off across my page here, but he essentially was making the point that it doesn't violate this subpart or this section of the regulations if the avoided cost at the time of delivery differ from when the contract's established or the legally enforceable obligations incurred. Is that your recollection of that discussion?
Yes,
And that was from Order 69, which was the original purple order back in the early 1980s. Is that right?
that's correct.
And the general principle is when you're fixing avoided cost rates at the time, FERC, and I think this is what Mr. DeGrandis was sharing with you, overpayments and underpayments would theoretically balance out over the term of the contract. So you don't have to have avoided cost rates that are absolutely accurate on a minute-by-minute basis. That was the discussion y'all were having?
Correct, and that was referenced in that summary that he shared on the screen.
Right. And didn't FERC in Order 872 express some concern? And I'm sorry, Order 872 is the recent July 2020 order that FERC issued. And didn't they express some concerns about that policy that overpayments and underpayments would balance out and the risk to customers of stale avoided cost rates?
Yes, they did reference stale avoided cost rates.
And that in practice, in jurisdictions across the country, overpayments and underpayments hadn't necessarily balanced out over time.
That is correct.
Okay. And so the more stale the avoided cost rates are, the more risk it creates for customers because they're less accurate. Is that generally the way avoided costs are calculated?
Yes, that's a fair statement. And that's why we try to, when we're negotiating larger QF PPAs, try to have the more accurate, up-to-date avoided cost rates.
Exactly. And that's the point that you were making to Mr. DeGrandis that I wanted to have a little further discussion of. Is I think you mentioned that this commission has also emphasized that point in its prior orders. Do you recall that discussion with Mr. DeGrandis?
Yes, I do.
And were you referring to the commission's order in the 2019 avoided cost proceeding that I had shared with Mr. Strunk earlier in the week?
Yes, the 881.
That's right. And that's what
Yes.
I've put on the screen here again. And just to go through that briefly, because it is an important point, I've gone to page 81 of the order where the commission is discussing this issue, and I'll just read it and you can give your commentary on it to the commission. So they're discussing the appropriate methodology.
Attorney Breshford, if you would
Yes, sir.
expand or enlarge that document for us, please, sir. Thank you.
Sir. All right. And I think the commission here is discussing the methodology for calculating rates for large QFs, and they're speaking about the Power Advisory Report, which was their expert independent consultant back in 2019, and it says, the Power Advisory Report also recognizes the improved precision of calculating avoided cost rates for large QFs at the time of the request, which ensures that the avoided cost rates reflect current assumption and avoids the risk of stale avoided costs, which can be more significant for large QFs. Power Advisory further recognizes that the avoided cost rates will reflect the specific operating profile of the large QF and result in more reliable avoided cost rates. The Commission agrees with Power Advisory and Duke that these considerations are appropriate in applying the Peaker methodology to calculate avoided cost rates for QFs above 2 megawatts not eligible for the standard offer. So this concept of using the most current assumptions at the time the commitment or the contract's established, what is this the point you were making to the Commission earlier?
Yes, it is that you want to go with the most current avoided cost rates, you know, because these large QFs are much bigger than the small ones. I mean, if you're talking about 98 megawatts, that's a big number, and that risk of overpayment could be high if you're not using the most current avoided costs.
And I'm not sure if you heard Mr. Keene's testimony yesterday, or I think it was Mr. Keene's testimony about the security issue and the delta of $3 to $6 million between what Duke has projected avoided costs to be in 2021 and what's actually being paid under the old 2012 contract. But that's the risk if you have stale avoided costs that continue over time, is that overpayment can occur.
That's correct.
Okay. And then you also had some questions from Mr. DeGrandis about why didn't DEC and DEP just figure it out? Why didn't they decide, you know, they got Mr. Keene on behalf of both companies got this letter, and why didn't they just figure out how to share power between the two companies? And I think your testimony was they're both independent utilities. They're separate. They serve separate customers. They plan for separate resources. They're completely independent. So that didn't really make sense. Was that generally the testimony that you shared?
Yes, but yes, they plan separately. They operate independently. They have separate customers. Yes.
And just to be clear, each of the letters, and I think Mr. DeGrandis put one of them up on the screen, but they designated that that Cherokee was intending to sell its full output to one utility, either to DEC in September of 2018 or to DEP in December of 2018. Isn't that right?
That's correct.
Okay. And just big picture, in your history of working for the Duke companies in the Carolinas, have there ever been joint purchases of QF output?
Not that I'm aware of.
Okay, thank you. And the one final issue, that there's a number of questions from the Commission on this concept of what is a non-contractual legally enforceable obligation, and it's a hard concept, and I know that we're all wrestling through it, but maybe just to reiterate your testimony, what is a contractual legally enforceable obligation?
The contractual is, you know, where there's the signing of a PPA. It's a contractual commitment to sell. You've signed an agreement to sell.
And that has all the detailed terms and conditions. I mean, that's the term of the contract, the indemnity provisions, the default provisions if one party doesn't perform. So that ultimately is the binding legal obligation that gives Cherokee the right to sell, but also gives the utility the right to receive that power and rely on it. Is that
correct?
Right. And in all circumstances, that's ultimately what would need to happen. There's no non-contractual legally enforceable obligation that would govern the relationship of the parties over the term of the contract. So once Cherokee starts delivering power, they would in fact have signed a PPA.
Correct. That's my understanding.
And so this issue of a non-contractual legally enforceable obligation is really the question of whether or not Cherokee has taken steps prior to committing in that PPA to demonstrate that it's going to sell and deliver power and that the utility has refused to commit to buy that power or obstructed the QF from making that contractual commitment, right?
That's correct.
Okay, and just real briefly, I think this is something that you addressed in your testimony, so I want to ask you a few questions about it to inform the discussion you had with Commissioner Belser and Kasten. But so this is on page 22 of your, let me make it smaller so you can get the context for it. But this is page 22 of your testimony, where you're talking about the process for negotiating PPAs with large QFs in South Carolina. And essentially you're explaining the concept that the QF can request an executable PPA and avoided cost rates and then have a set amount of time to sign that contract. Is that generally the process?
That's generally the process, yes.
And this standardized process results, and I'm just reading line 10 through 16, results in a PPA that memorializes the QF's contractual commitment to commence delivering power to the utility on its committed commercial operation date for the specified term of the PPA, while also ensuring the QF's making a meaningful and binding commitment to sell its power to DEC or DEP. And so is it fair to say that in the process with Cherokee, that's what the companies were giving Cherokee the, and I'm sorry if that wasn't on your screen there.
That's okay. I have it in front of me.
Okay, and I just will put it up again. And for the commission, I think that you were explaining and testifying earlier that it's the standardized process to ultimately get to that PPA that matters, and that's what the companies were giving Cherokee the opportunity to do. Is that generally the point you were making?
Yes.
Okay. And finally, Commissioner Kasten was asking some questions about this concept of a stake in the ground that we've heard about quite a bit from the Cherokee witnesses. And I think you agreed in your pre-filed testimony in your discussion that it's the LEOs based on the QF's conduct. Is that right?
That's correct.
Okay, so if it's based on the QF's conduct and ultimately the QF has to execute a PPA to sell and deliver its power, is it fair to say that the question for the commission in terms of a LEO is whether the QF has staked itself out in terms of committing to sell? It's not just they put a stake in the ground that they can walk away from, but they actually have to establish that they're making a commitment to the utility at the same time the utility is obligated to purchase that power over a future specified term, and that's what this non-contractual LEO concept is intended to accomplish.
That is correct. And I think I referenced a FLS case that said it turns on the commitment of the QF.
Right. Thank you for that. And I think that's all the questions I have. Ms. Bowman, thank you very much.
Thank you.
All right. Thank you, sir. Anything else for this witness? All right, ma'am, you may step down from the stand.
Thank you.
Call your next witness.
Mr. Chairman, that concludes the 4 witnesses for the companies. I'm not sure whether Office of Regulatory Staff was next or...
Yes, sir, they are. Office of Regulatory Staff.
Jeff Nelson here for the Office of Regulatory Staff, Mr. Chairman.
All right, call your witness, please.
Thank you. ORS would call Ms. Dawn Hipp as its witness.
Good morning. Can you hear me?
Yes, ma'am, loud and clear. Please wait to be sworn in by the court reporter.
Thank you.
If you would raise your right hand. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Ms. Hipp, can you please state your name and occupation for the commission?
Good morning. My name is Dawn Hipp, and I'm the Chief Operating Officer with the Office of Regulatory Staff.
And are you the same Dawn Hipp who pre-filed 7 pages of direct testimony with this commission in docket 2020-263-E on May the 24th of this year?
Yes, I am.
And do you have any changes, edits, or corrections to your pre-filed direct testimony?
No, I do not.
Thank you. And if I asked you the same questions today as those posted in your pre-filed direct testimony, would your answers be the same?
Yes, they would.
Thank you. Mr. Chairman, ORS asks the pre-filed direct testimony of Ms. Hipp be written to the record as if given orally from the stand.
The pre-filed direct testimony of Ms. Dawn Hipp will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Ms. Hipp, did you prepare a summary of your direct testimony?
I did.
Could you please present it for the commission?
Certainly. Good afternoon, Chairman Williams and other members of the commission. My direct testimony is limited in nature to ensure the customers of Duke Energy do not pay more than the appropriate commission-approved avoided energy and avoided capacity costs for the power supplied by Cherokee under the terms of any successor power purchase agreement. The cost of purchased power is directly passed through to all classes of customers without markup as fuel costs pursuant to the Fuel Adjustment Clause as found in Title 58, 27, 856. Under the current law, Duke Energy may recover from customers prudently incurred costs for power purchases, including avoided costs under the PURPA from qualifying facilities such as Cherokee. ORS does not engage in purchase power contract negotiations between QFs and electric utilities. The outcome of a successful purchase power negotiation results in a PPA that is filed with the Commission in accordance with Commission Order Numbers 81-214 and 85-347 and South Carolina Code 58-41-20 E1. Typically, ORS reviews PPAs filed with the Commission, and during the annual Fuel Adjustment Clause proceedings, ORS will review the negotiated and standard offer PPAs to verify that the fuel costs recorded by the electric utility are accurate and reflect the appropriate avoided costs. ORS became aware of the contract dispute on November 2nd, 2020, which was when Cherokee filed the complaint with the Commission in this docket. Upon review of the complaint, ORS discussed the complaint with representatives of Cherokee and Duke Energy, and in addition, ORS participated in a mediation session with an independent mediator selected by the parties on February 26, 2021. The mediation did not resolve the contract dispute between the parties. Today, ORS provides information and a recommendation related specifically to two issues identified in Cherokee's complaint: the determination of avoided costs during the hearing of the complaint, and to provide the interim relief in the form of a continuation of payments from Duke to Cherokee under the existing PPA while the Commission issues a ruling on the complaint. ORS reviewed the complaint, testimony, and discovery responses and focused on the impact of the complaint and possible outcome to all customer classes. ORS recommends the successor PPA for Cherokee reflect avoided energy and avoided capacity rates calculated based on the methodology approved by the Commission. The customers of Duke Energy will pay directly for the purchased power costs, and they should not pay more for purchased power from QFs. From the perspective of the customer, the ceiling for energy and capacity payments to a QF is one that is based on Duke Energy's actual avoided costs. The Commission approved two temporary extensions of the current PPA between Cherokee and Duke Energy for the time period of January 1st through August 28th, 2021. ORS objected to the most recent temporary extension of the current PPA due to the absence of proper safeguards to protect Duke Energy customers from increased purchase power costs. in the event that the commission determines that the going forward price to be paid by Duke Energy to Cherokee for power generated by Cherokee is less than the price paid under the 2012 PPA, ORS recommends the dollar amount attributed to the incremental overpayment to Cherokee due to the extension be credited or refunded to Duke Energy customers in a manner to be determined by the commission. The credit or refund to customers can be accomplished through lower payments to Cherokee under any successor PPA. It's important to note that because Cherokee is not under the jurisdiction of the commission, the customers of Duke may bear the entire burden of the overpayment if a successor PPA is not reached between Cherokee and the company. The estimate of the overpayment is not insignificant, and neither Duke Energy nor its customers should be harmed if the commission ultimately determines that the rates to be paid by Cherokee under a new PPA are less than the current 2012 PPA. It is ORS's position that Cherokee should bear the economic risk of any extensions of the current 2012 PPA. ORS reserves its right to review and examine the amount of any overpayment, the payment amount itself, the terms, and the condition of a successor PPA. ORS may make recommendations to protect customers in any future proceeding where the cost of purchase power may be recovered from customers. This concludes the summary of my direct testimony.
Thank you, Ms. Hipp. Mr. Chairman, Ms. Hipp is available for questions from opposing counsel or the commission.
Cross-examination.
Mr. Chairman, Frank Ellerby for DEC and DEP. I've got a few questions for Ms. Hipp.
Go right ahead, sir.
Thank you. Ms. Hipp, in your summary and in your pre-file testimony, you indicated that ORS first became aware of this dispute and this complaint when the formal complaint was filed with the commission. Is that right?
That's correct.
Does that mean that Cherokee or LS Power, neither of those entities reached out to ORS to ask for assistance in facilitating a resolution of the matter prior to that time?
It is my understanding that we did not hear from either LS Power or Cherokee.
And I know that we all know that the ORS role was changed by act of the General Assembly in the last couple of years, but the ORS role of facilitating resolution of disputes, it continues. That role is still on the books, and ORS still has that role. Is that correct?
Yes, we do.
Okay, thank you. I think you were very clear. I don't believe I need to ask you to explain further why ORS is concerned about this case, but I think it is worth highlighting that for non-QF, non-PURPA PPAs, ORS does have a role to play, but it's after the fact when the company attempts to recover in a fuel proceeding for payments under PPAs. That's an issue that ORS can raise in a fuel proceeding. Is that right?
Correct.
Okay, but in this proceeding, the reason ORS has taken a more active role in this complaint proceeding is because you're concerned that the rates be set at avoided costs so that customers will not pay more than avoided costs, right?
We are monitoring this proceeding for two reasons: the outcome of the successor PPA, and the second reason is an interest in the overpayment that is currently occurring under the extensions of the current PPA. And that is frankly the reason why we filed testimony. Otherwise, you could expect to see us monitor the case.
The ORS has been actively involved in both the 2019 and the 2021 avoided cost proceedings by DEC and DEP. Isn't that correct?
Yes, we have.
And you've retained the outside consultant E3 and Mr. Brian Horry has testified for ORS in those proceedings. Is that right?
He filed testimony in both cases.
And so it'd be fair to say that folks at ORS are well informed about the appropriate level of avoided costs for DEC and DEP.
Yes.
And in addition, ORS sent audit information requests to both DEC and DEP as part of this proceeding to get more information upon which ORS based its position in this case.
We did issue discovery.
And you have indicated in your testimony that it's the ORS position that the contract that expired at the end of last year and was extended is significantly above the company's current avoided costs. Is that right?
The rates in the 2012 PPA and the subsequent extensions are higher than the current avoided cost rates for the company.
Okay. Thank you, Ms. Hipp. I have no further questions.
Thank you.
Cherokee, any questions for this witness?
Yes, Mr. Chairman, thank you very much.
Attorney Pringle.
Ms. Hipp, good afternoon.
Attorney Pringle.
Yes.
Before you get started, we need to take a 5-minute break. We'll be back at 12.
That's lucky for Ms. Hipp, I'll tell you that. Yeah, no, that's fine.
12:35. We're in recess until 12:35. All right, ladies and gentlemen, we're back at the Public Service Commission in docket number 2022-63E. Let's take roll. Present in the hearing room are Vice Chair Belzer and Chairman Williams. Joining us virtually, we have Commissioners Powers, Thomas, Urban, Caston, and Williams. Let's see, do I see everyone? Powers, Thomas, Urban, Caston, and Williams. All right, let's proceed.
Thank you, Mr. Chairman. Ms. Hipp, good afternoon.
Good afternoon.
Are you still going by Chief, or is it Hefe, or it's been a while?
Jack, it can be anything you'd like to call me. I will answer.
All right. Well, I certainly appreciate that. You just had a conversation with Mr. Ellerby where he mentioned that that Cherokee did not approach or inform ORS prior to the complaint being filed. Do you remember that conversation?
Yes, I do.
Okay. Let me just I'll put your testimony on the screen here real quick, and I will adjust it appropriately. Let's see. How's that looking, everybody? A little bit bigger, or is that good?
You're good to go.
Oh, excellent. Okay. Let's point you towards the highlighted language in your testimony at lines 10 and 11 and get you to read that.
My testimony reads, answer, no, typically ORS does not engage in purchase power contract negotiations between QFs and electric utilities.
Okay. All right. And then you also made a point later on, and I'll just go ahead and get to this, about ORS's position in this case. Essentially that ORS is not really taking a position on the disputed issues. Is that correct?
My testimony reads that we're rendering no opinion on the negotiation process, the date upon which a legally enforceable obligation was established, and the applicability of the form, structure, and term of the successor PPA to be filed with the Commission.
Understood. And have you had a chance to listen to some of the testimony of the witnesses in this case?
I was able to listen to the testimony on Monday.
Okay. And from that testimony, whether it's from, although actually Monday is so long ago, I'm not even sure what year it was in, but Mr. Hansen and Mr. Strunk and others, that one of the disputed issues in this case is, as you mentioned, the date on which a legally enforceable obligation was established, correct?
I'm trying to recall if I heard either one of them testify to that. Subject to check. I would agree that that is an item that seems to be in dispute.
Okay. And that the existence or the establishment of a legally enforceable obligation may affect when or the point in time at which avoided costs are determined, correct?
I heard a witness for Duke discuss the option of the QF as to determine the avoided costs at the time of the LEO. Yes.
Okay. So avoided costs could conceivably be determined as of the time of the LEO at the conclusion of this proceeding, or this commission could do that, correct?
The avoided cost determination, it is our position, should follow the commission approved methodology. So if your question relates to whether or not the commission will determine an avoided cost methodology that is different from that which they have recently determined for Duke, my answer to that would be no. If it's following that methodology and the commission were to determine that on this date, our approved methodology and resulting rates should be approved, that would be in keeping with our testimony.
Okay. And following up on that, the commission could decide that Duke's current avoided costs are not the appropriate avoided costs for purposes of a successor PPA, correct?
The commission, we encourage the commission to hold the structure that they have approved. If the commission determines that the avoided costs at this point in time, as determined by the commission, are not acceptable, and they choose an avoided cost methodology in line with the case that was litigated in the 2019 time period, we encourage the commission to adhere to the methodology that it has approved for large QFs.
Okay, and I apologize. I think I'm not being clear in maybe the assumptions or what I'm actually asking you. And I'll posit that putting aside the methodology, I'm not asking you anything about the methodology that the commission might use to make the determination. My question is whether or not, based upon the establishment of the LEO, that the commission may be determining avoided costs not according to a different methodology, but calculated as of a different date, specifically September of 2018, as opposed to calculated very recently or currently.
Attorney Pringle, are you finished sharing your screen or finished with that document?
Well, I was going to keep moving through the document. I can stop sharing it right now and then just put it back up.
Thank you, sir.
Yeah.
Mr. Pringle, with the caveat that you offered that the methodology is that your client is not seeking a different methodology, I would agree that the commission's determination of the timing will determine the avoided costs at that time.
Okay. All right. And let me also then, I appreciate that. Let me also then just put this screen back up. You also mentioned that currently Duke Energy's customers are paying significantly more than Duke Energy's actual avoided costs under the extensions of the 2012 PPA with Cherokee. That's your testimony, right?
That is correct.
Okay. And if the commission, as we just discussed, approved an avoided cost established as of another point in time, that statement might be different, correct?
Depending on what the commission determines, avoided costs have declined since the 2012 PPA was entered into, and so it is reasonable to expect that the avoided, the payments related to Duke's avoided costs will decline to Cherokee.
Sure, but you use the term actual avoided costs, correct?
That is what my testimony says.
And those mean current avoided costs?
That is correct.
Okay, let's keep moving. You also mentioned, and this sort of carries over on a couple of different pages, on page 6 and page 7 as stated in Duke Energy's letter, Duke Energy of April 20th, 2021, Duke Energy customers have paid close to $1 million over the current avoided cost rates. Is that correct? A
That is
correct
what
reading
Duke-
of your testimony?
That is a correct reading of my testimony.
Okay, that is based upon what Duke said.
That is based on the letter which I cited to in my testimony.
Okay, and your testimony doesn't contain any analysis or review of that assertion, does it?
No, my testimony does not contain any verification of that amount.
Okay. And with respect to overpayment generally, and I understand and appreciate the ORS's concerns for the public and those customers of all types of utilities. But with respect to this specific issue of whether it's how much was being overpaid or the risk of non-payment, did you approach Cherokee to ask any questions of Cherokee about, for example, their credit arrangements with Duke, or their view or its view of whether overpayment was taking place?
We did not. We did ask discovery on Cherokee, and it was simply to provide information that it had provided to other parties in this case, but we did not ask that specific question.
Sure, understood. And you have, Ms. Hipp, and this will be my last question, you have dialed my phone number before, correct?
I do know your phone number, yes.
Okay, all right. Well, I very much appreciate your time, and I hope that the events of the week didn't upend your schedule too terribly much. And I hope we have you back out working on, some other matters of great pith and moment very soon. That's all I have, Mr. Chairman.
Thank you, sir. My plan is to break at 1 o'clock. Do we have commission questions that we can address in 10 minutes, or do we need to just break now and come back at 1:45?
Chairman Williams, I have two quick questions.
2 quick questions. Anyone else have any questions, commissioners?
Commissioner Thomas has a question or two.
Okay. So we got 4 questions. Let's see if we can knock them out. We got some more questions.
Yes.
Okay.
Commissioner Williams has a few.
All right. Let's see if we can knock them out in 10 to get Ms. Hipp out of here. If not, we'll come back at 1:45. Commissioner Thomas.
Thank you. Ms. Hipp, you probably didn't hear what was going on yesterday, I would assume, is late yesterday. Is that correct?
That is correct.
Okay. Well, let me mention something to you that I've been thinking about, and I asked Mr. Snyder yesterday a question, but I'm still kind of just wondering about this. And what this relates to is that Cherokee has a business relationship with an ice company, and so presumably they're making money through that relationship. So my concern is this. My understanding is that Duke is the one that pays the bills for the gas. They buy it from Transco. They pay for transportation for Transco. And then Cherokee uses that to produce the power that Duke acquires. And I guess it's heat or steam or something that goes to the ice company, and they make money on that. Cherokee does. So my concern, I guess, is that there's nothing in the avoided costs that helps Duke customers as a result of Cherokee making that money. And I'm assuming that all of those gas costs that Duke pays in transportation also end up going through the fuel adjustment and the Duke customers end up paying that. It just seems to me that if Cherokee's making money, and I don't know that this is what's happening, but if Cherokee is making money off of the expenses of Duke, it just seems to me like the Duke customers should get some sort of benefit back through the system. Does that make any sense to you? I mean, am I even going in the right direction?
Well, I wasn't able to hear the testimony that was given yesterday. I think it is a question that is something that the company can illuminate further on, but there is a netting process. I mean, we look very carefully in the fuel adjustment clause review to ensure that if a relationship between a QF and the utility occurs where fuel is provided for the in exchange for the power or provided to the QF, that there's a netting process such that the customers don't pay for the fuel to power Cherokee's combined their CT, and then they don't pay for the purchased power, that there's not a double dipping. I'm not close to that review arrangement, and I think the company would be in a better position to answer your question about how they net the fuel that they purchase on behalf of Cherokee's operations with the power that they purchase from Cherokee, such that the customers don't pay for both.
Okay, thank you. I appreciate that. That's all I have.
Chairman Williams.
Commissioner Caston.
Good afternoon, Ms. Hipp.
Good afternoon.
When this is resolved, and should there, which there seems to be perhaps, should there be an overpayment because of the extensions? Should there be interest accrued? Should interest be added to that overpayment for payback?
Commissioner Caston, I'm glad you're asking that question. There has been some discussion about how the overpayment should be handled if the commission determines that there is one. It is our position that the customers should not bear the burden of that. As I had said in my direct testimony, the customers are currently paying the 2012 PPA rates for that power generated by Cherokee. And if it is determined that Cherokee should receive a longer time for the true up of the overpayment, then certainly carrying costs or interest should accrue to the benefit of the customers. I believe that had been a discussion about a period of time for which that overpayment could be looked at by the commission, and we would encourage that the period of time where the overpayment is occurring, it started on January 1st, 2021, through whatever time period the commission issues its order, that is the time period for which any overpayment refund to customers be utilized.
Commissioner Caston, before you ask your next question, I'm going to ask all participants to mute their microphones unless they're speaking. We're getting some background noise in the hearing room.
Yes, sir. And if I understood you, I guess in your response to Mr. Pringle, I was going to ask you, does ORS have an estimate if the September 2018 avoided cost rate was the rate? I was going to ask if ORS has an estimate of what the overpayment would be based on that rate, but I think I heard from your response to Mr. Pringle that you probably do not. Is that correct?
That is correct. We have not made that calculation.
That would be real useful, I guess, to have all these, because there's been so many numbers thrown around, so many dates. That would be good to have. But that's all the questions I had. And thank you so much, Ms. Hill.
Commissioner Williams.
Thank you, Chairman Williams. Hello, Ms. Hip. Thank you for your testimony. I have two questions. One is, and you may not be able to answer either one of them, but in the mediation efforts, was there discussion about the rate offered on February the 10th of this year?
Well, the mediation was held back in February, and we were, of course, separated into 3 different rooms. It was not, if it was a discussion, I don't recall.
Okay, thank you. And did ORS evaluate Duke's inputs in using the methodology for the avoided cost rates that they proposed at each step in this process, at each of the various rates offered?
The time at which ORS reviewed Duke's inputs was during their avoided cost proceeding, when we offered our positions to the commission and the commission made its decisions. We did not independently review the inputs in the context of this complaint between Cherokee and Duke Energy.
Thank you very much. That's all.
Thank you.
Any redirect?
No redirect questions from Ms. Hip. Thank you, Mr. Chairman. ORF would also ask if there's nothing further for her, that Ms. Hip please be excused.
Ms. Hip is excused. We're in recess until 1:45. Good afternoon, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in docket number 2020-263E. Let's take roll. Present in the hearing room are Vice Chair Belzer, Chairman Williams. Joining us virtually are Commissioners Williams, Thomas, Powers, and Urban, and Caston. All right, Attorney Pringle, please proceed.
Mr. Chairman, I believe that Mr. DeGrandis is going to present this witness, Mr. Strunk.
Yes, that's correct. Good afternoon, Mr. Chairman.
Good afternoon, sir.
Our first rebuttal witness is Mr. Kurt Strunk, so we would like to call him to the stand, Mr. Chairman.
Mr. Strunk, please retake the stand. Now, at the beginning of this hearing, Attorney Pringle requested without objection that he have the opportunity to talk with his witnesses between direct and rebuttal. That request was granted, so the witness has been under oath the entire time, and I'm not going to require him to be resworn. All right, Mr. Strunk, please take the stand and answer any questions.
Good afternoon, Mr. Chair. Good afternoon, Commissioners. Good afternoon, Mr. DeGrandis.
Good afternoon, Mr. Strunk. Would you please state your full name and business address for the record?
My full name is Kurt Strunk. My business address is 1166 Avenue of the Americas, New York, New York, 10036.
And by whom are you employed and in what capacity?
I'm employed by National Economic Research Associates, NERA for short, and I'm a managing director in NERA's energy practice.
Thank you. Have you caused to be pre-filed rebuttal testimony dated June 14, 2021 in this proceeding, Mr. Strunk?
Yes, I did.
Do you have any additions, deletions, or changes to make to that pre-filed rebuttal testimony at this time?
No, I do not.
If I asked you all the questions that appear in your pre-filed rebuttal testimony, would your answers today be the same as appear therein?
Yes, they would be.
Mr. Chairman, I would ask that Mr. Strunk's pre-filed rebuttal testimony dated June 14, 2021 on behalf of Cherokee Cogeneration Partners, LLC, be read into the record as if given orally from the stand.
Mr. Strunk's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Strunk, did you have any exhibits to your rebuttal testimony?
I do not believe so, no.
I think you're correct.
Okay, thank you.
Thank you. And Mr. Strunk, do you have a summary of your rebuttal testimony that you'd like to present at this time?
Yes, I will present a brief summary of my rebuttal testimony. And in so doing, I will group the statements in my rebuttal testimony into three general topics. The first topic deals with whether Duke's statements in its testimony are consistent with its actions. The second topic deals with the appropriate avoided cost inputs, why Duke's inputs are inappropriate, and why the inputs I have used are reasonable. And the third topic is whether Cherokee was seeking a rate above Duke's avoided cost. I will now explain my rebuttal positions on these three topics. Again, the first topic is whether Duke's statement in this case square with its actions. And this is very important to the Commission's review of the facts and analysis of the reasonableness of Duke's position. In Duke's presentation of this case, the utility argues that it did nothing wrong. Duke suggests that it was Cherokee's fault for not entering into the PPAs that were offered to it. Yet, when one reviews the facts in detail, one can see that Duke's actions do not support the testimony. The utility is saying one thing and doing another. Let me give you a few examples. Mr. Keene testified that he works for Duke's customers, and Duke's arguments have been cloaked in this idea of protecting customers. but the actions of Mr. Keene and the other DEC representatives did not put retail ratepayers' interests first. My rebuttal testimony explains exactly how the actions by DEC were not in the best interests of customers. Specifically, the must-take contract that DEC proposed to Cherokee in October of 2018 on a take-it-or-leave-it basis was unattractive from the perspective of Duke's customers. A must-take contract for a dispatchable gas plant will embed rigidities and inefficiencies that result in higher fuel costs for Duke's customers. It is important for the Commission to recognize that must-take in the electric utility industry has a negative connotation. Best practice in wholesale power contracting would call for utilities to avoid must-take agreements with power generation facilities that have the flexibility to be dispatched. Under a must-take agreement, Duke's retail ratepayers will see millions of dollars in unnecessarily high costs flowing through Duke's fuel rider. In a must-take arrangement, these unnecessary costs arise in situations where Cherokee's dispatch cost is above the PPA price, but below the cost of Duke's other resources. Unnecessary costs will also accrue when Cherokee's dispatch cost is below the PPA price, but above the costs of Duke's other resources. Structuring this contract as a must-take agreement forecloses opportunities for DEC to achieve fuel savings to the detriment of Duke's ratepayers. These facts confirm that the DEC's October 2018 offer was unreasonable, and all of the written offers from DEC and DEP to Cherokee before Cherokee filed its complaint were based on this inefficient construct. It was an inefficient contract structure that harms Duke ratepayers. Another instance where the DEC testimony does not square with the actions of the utility relates to the negotiation process. The guidance from this commission was for DEC to negotiate an avoided cost rate for large QFs like Cherokee. But the evidence shows that DEC was unwilling to negotiate a rate and instead took a take-it-or-leave-it approach. Mr. Keene testified yesterday that the contract length was one area where Duke has some flexibility to negotiate with large QFs. Yet the evidence on record shows that Duke did not provide any written offers that extended the term of the contract until after Cherokee had filed its complaint. On the subject of the LEO, Duke clarified that witness Bowman does not contend that the QF and the utility must agree on the appropriate avoided cost rate for a LEO to be established. Yet the testimony from the other DEC representatives, including Mr. Keene, who led the negotiations, and Mr. Snyder, was that as a practical matter, Duke doesn't recognize a LEO unless the QF agrees to the quoted avoided cost.
Mr. Chairman, I apologize. This is about the fourth time that Mr. Strunk has quoted Duke witnesses in the hearing this week. And just as a point of clarification, my understanding of the objective of a pre-filing summary would be to summarize the pre-filed testimony versus having a direct argument in response to the hearing testimony that was presented. I think we've been challenged on that in the past and tried to tailor our summaries to reflect the page numbers and the detail of the testimony that was pre-filed. And so I let it go twice before raising it with the commission, but it does seem this is getting a little far afield of what Mr. Strunk's actual pre-filed testimony addressed.
Sustained.
Okay. Thank you, sir.
Okay, well, I'll just say that, if you do look at the specific text of my testimony, it says that, the DEC witnesses had pre-filed testimony saying that they followed the guidance from the FERC and the commission. And all I'm saying here in this case is that they didn't follow the guidance from FERC and this commission. And the record in the case basically includes the contentions by the Duke witnesses that they acted in good faith, consistent with their obligations under PURPA, but the specific actions, as I explain on pages 5 through 13 of my pre-filed rebuttal testimony, on pages 5 through 13, I explained the specific actions of Duke do not support the contentions and in fact demonstrate a lack of good faith negotiations. The second point in my rebuttal testimony relates to avoided cost inputs. My rebuttal responds to Duke's testimony regarding my inputs and highlights that I rely on rates and inputs for avoided capacity that had been approved by this commission. I do this because the inputs are by nature very contentious and are typically subject to dispute in adversarial avoided cost and IRP proceedings. Duke's position seems to be that whatever updates to the avoided cost rates that are made need not be subject to any scrutiny. Duke also characterizes the avoided costs as a single set of numbers. Yet, as we've seen, and as the commission is aware from the scheduled PP rate that I refer to and rely upon in my testimony, the rates for an avoided cost 5-year PPA could be different from the avoided cost rate for a 10-year PPA. So there's no single avoided cost rate. And there is room for the utility and the parties to negotiate. And I explain in detail that in my rebuttal testimony that I rely on input and rates for avoided capacity that had been approved by this commission. I do this because the inputs are by nature very contentious and typically subject to dispute in the proceedings I referred to, avoided cost and IRP. In a large QF negotiation where Duke does not disclose the key inputs that drive the assumptions and does not allow the QF a reasonable diligence process, it's reasonable to look to and rely upon the assumptions that were approved in contested proceedings. So in summary, on the second topic, which is the avoided cost inputs, my rebuttal testimony establishes that my avoided cost capacity assumption is reasonable and consistent with authorized avoided cost capacity rates that were being offered by DAC and were approved by the commission. A third point in my rebuttal testimony addresses whether Cherokee was seeking rates above avoided costs. And I explain in my rebuttal testimony that that's not the case. Cherokee was trying to engage in a diligence process, which is appropriate for a transaction of this size. And I think, as was, I hope I will have an opportunity to discuss the responses to to the second set of interrogatories, which were received by Cherokee after I filed my rebuttal testimony. Because I think those responses shed quite a bit of light on whether the offers were reasonable and whether or not Cherokee was in fact seeking too high a rate or whether they were seeking a rate that reflected more reasonable assumptions with respect to the avoided cost forecast. And my rebuttal testimony establishes that the 2018 offer in October did not reflect reasonable forecasts of avoided capacity costs at that time. Incorporating capacity costs in a 2018 avoided cost forecast yields a rate of $110 per kilowatt year, inclusive of start costs. That concludes the summary of my rebuttal testimony.
Thank you, Mr. Strunk. Mr. Strunk, please answer the questions the parties or the commissioners may have. Mr. Chairman, we tender witness Strunk for cross-examination.
Cross-examination.
Thank you, Mr. Chairman. Good afternoon, Mr. Strunk. Again, Brett Bryceworth on behalf of the Duke Companies. How are you today?
Good afternoon, Mr. Bryceworth.
So just a couple brief topics I want to cover with you that you somewhat addressed in your summary and were addressed in your rebuttal testimony. The first is whether the rates offered to Cherokee were discriminatory, and then I want to have a conversation about the methodology that was appropriate to use in calculating the avoided capacity costs for Cherokee. So I'd first like to start off on page 12 of your testimony at line 1, if we could please, sir.
Yes, I'm there.
All right. Could you read lines 1 through 5 for me, please?
Lines 1 through 5 read as follows. It was also not just and reasonable because it was discriminatory. As I explained in my direct testimony, the October 2018 offer to Cherokee was discriminatory because DEC was offering other QFs rates that provided compensation for avoided capacity costs, but was not offering that compensation to Cherokee.
And you recall we had a conversation about this issue of whether the rates were discriminatory on Monday during your direct testimony?
I do recall that, yes.
Okay, and so on line 3, you say DEC was offering other QFs rates that provided compensation for avoided capacity costs. What other QFs are you referring to when you make that statement?
QFs that were initiating contracts in the fall of 2018 under the PP rate that had been approved.
And to be clear, the PP rate is the standard offer rate, correct?
That's correct.
And that means it's limited to small QFs, 2 megawatts or less, and would not be available to Cherokee, correct?
Yes, we went over that on Monday.
Right, and so based on the testimony this week, have you heard anything that would allow you to draw the conclusion that Duke treated Cherokee differently than any other large QF that was also not available for the standard offer in calculating avoided capacity rates offered during the relevant period of time, the fall of 2018?
So I can explain what I heard. What I heard was that Duke treated the large QFs the same as Cherokee, but most of the large QFs, as I understand it, were solar intermittent facilities. So in that context, it wouldn't be appropriate for Duke to treat Cherokee, a dispatchable facility, in the same way that it treats non-dispatchable must-take solar QFs.
And you introduced this concept on Monday, so I want to explore it a little bit more. But the dispatchability versus the must-take is relevant in terms of the rate design. That's not relevant in terms of quantifying the avoided capacity value that the utility is avoiding. That methodological issue is determined prior to setting the avoided cost rates that are paid to QFs. Wouldn't you agree with that?
So, well, the form of contract could affect the avoided energy cost, but in terms of how that's valued, because as we saw in response to the second set of Cherokee's interrogatories, the company used a very different analytical process when it evaluated Cherokee as a dispatchable resource for its February 2021 bid or offer than it used when it presented the avoided energy cost rates to Cherokee in October of 2018. So I agree with you that it wouldn't necessarily affect the avoided capacity, but it could affect the avoided energy.
Okay, so just thank you for that response. But just to be clear, in valuing the avoided capacity, which is really the disputed issue between you and Duke in terms of those 2018 avoided cost rates, the first year of need, the methodology, that would not be impacted in the way that you just explained the avoided energy rates would be impacted. You agree with that?
Yes, but at the time, the most recent order from the commission had adopted the NCUC approach where the avoided capacity need date really becomes irrelevant, because in that NCUC order, that North Carolina order, the commission had said, we reject Mr. Snyder's approach where he's putting zeros into the early years of the avoided capacity cost levelization formula.
And we're going to talk, thank you, we'll talk about that North Carolina order in a moment. All right, so just to be clear, in terms of discrimination, there was no difference between Cherokee and other large QFs. The point you're making in your testimony is there is a difference between the way Cherokee was treated versus other small QFs that were eligible for the standard offer, and that's the premise you're using, or the comparison you're using to make your discrimination argument. Is that accurate?
That's accurate, and as I just stated, I also believe that it was inappropriate for Duke to treat Cherokee, a dispatchable resource, the same way it treats non-dispatchable large QFs.
Okay. All right, if you turn to page 13 of your testimony, so I think you went over this in your summary, but this is the section where you're focused on the differences in the rate calculation between the methodology that you're proposing and the methodology that Duke used to develop those avoided cost rates back in 2018. Is that right?
Yes, beginning on line 3.
Yes, sir. Thank you. And did you hear ORS witness Hip's testimony earlier today?
Yes, I did.
Okay. And she was pretty clear in her testimony that the avoided cost rates for Cherokee should be calculated based on a methodology approved by this commission in the most recent 2019 avoided cost proceeding. Did you hear that testimony?
Well, I didn't interpret it that way, but I did hear that she was saying that that she thinks the methodology should be the most recent approved methodology. I think that's right, but she also said she wasn't taking a position on the LEO. So, you know, if the commission were to decide that the LEO was established in September 2018, then you'd have to look at the methodology that was applicable at that time. So in that regard, I think her testimony is a little bit misleading, and perhaps could require some clarification as to the record.
Okay, and I just want to confirm that what I heard her say, and just before your opinion on it, was that her opinion on behalf of the ORS was that the avoided cost rates for Cherokee should be calculated based on the methodology approved by this commission in the 2019 avoided cost proceeding. Was that what you heard her say as well?
I didn't hear her say specifically 2019, and maybe I had stepped away from my computer, but I didn't hear the 2019. I did hear her say that it should be a consistent methodology.
Okay, but that is the most recent methodology that's been approved by this commission, correct?
Right. So if the commission were looking at forecasting avoided costs today, that would be the most recent approved methodology, and that would be consistent with Ms. Hip's testimony. But if they were looking back to 2018, I think the logical extension of Ms. Hip's testimony is that they'd have to be looking at the avoided cost methodology that was in place at that time.
Okay, and just to be clear, the methodology that Duke used back in 2018 is consistent with the methodology that was ultimately approved in the 2019 avoided cost proceeding, which Ms. Hip on behalf of the ORS said was the appropriate methodology to use today. Isn't that correct?
So you've bundled a whole bunch of questions there, and I had already answered the question about whether Ms. Hipp's testimony, and I don't think I answered it in the way you characterized it.
Okay, well, let me
If you
break
could unpack the questions, I'd be very appreciative.
Understood. So Ms. Hipp said use the most recently approved methodology. I think you've answered that question, so I won't ask it again. But it's Duke's position also that the commission or that the companies used the most currently approved methodology from that 2019 avoided cost proceeding in calculating the avoided capacity rates paid to Cherokee, correct?
That's right.
Okay. And that's not the position that you are taking, correct?
The position I'm taking is that the methodology that was implicitly approved in the 2016 order, which was the last avoided cost order from this commission at the time of the for DEC at the time of the September 18th letter from Cherokee to Duke to DEC. That's the methodology I believe should be applied because it was the then current methodology.
Implicitly.
Right. It was based on the settlement. It was a settlement that referred to what happened in North Carolina. And in North Carolina, they had said you have to pay the QF for capacity in every year of the contract.
Okay, let's talk about this in a little more detail because you actually address it on page 15 in some detail in your testimony, don't you?
Yes.
Very good. All right. So let's start with page 15, line 1. And this is the same discussion we were just having about what's the right methodology to use, the one that Duke used in September 2018 and the ORS supports, and or the methodology that you used in your testimony. Line 1 says the DEC arguments in this regard are unpersuasive. They're premised on an assumption of zero capacity credit that the North Carolina Utilities Commission had rejected, and this commission had also implicitly rejected when it allowed the North Carolina rates in South Carolina. And then you have a footnote 31 there. So I want to break this apart because this is a really important issue for the commission to understand. Let's start with the statement on line 2 that the North Carolina Utilities Commission had rejected that. I have provided 2 hearing exhibits to your counsel. The first I'd like to show you at this time. Share my screen. All right, and Mr. Strunk, I should have, when I sent this to your counsel, I also sent it to you, so it should have been in your inbox maybe 30 minutes or so ago. But does this order from the North Carolina Utilities Commission look familiar to you?
Attorney Briceford.
Yes, sir. I'm going to enlarge the document. I'm guessing that's where we're going next. Let me, Mr. Chairman, I just wanted to give him the full
Thank you.
view of the page before doing so. So let me just walk through it briefly with you, Mr. Strunk, and maybe this will refresh your recollection because you actually testified in this case. So the order you're relying on.
Yes. So the answer is yes, it's familiar to me.
Very good. So the order that you're relying on for the North Carolina Utilities Commission rejected Duke's position assertion was from docket E100 sub 140. Is that correct?
Subject to check, yes.
Okay, well, it's in your pre-filed testimony, footnote 24 on page 12, if you'd like to refer there, and it's dated December 31 of 2014. See that in your testimony?
Footnote, I'm sorry, what's footnote number?
Footnote 24 on page 12 of your rebuttal testimony.
Yes, that's right. So it was from sub 140. That's correct.
That's correct. And that was December 31st of 2014 was the date that order was issued.
That's right.
And throughout this case, timing matters, I think, is one of the important things. So this case was E100 sub 148, which occurred after the sub 140 docket, if we can call that the prior order you cited, and this is the sub 148 docket. and this is not the full order, but is an excerpt of the relevant sections. And Mr. Chairman, at this time, since Mr. Strunk has recognized that he's familiar with the document, I would ask this to be what has been pre-marked as Strunk Cross Exhibit 4 be accepted as the next hearing exhibit.
Strunk Cross Exhibit 4 will be. Everything okay? Strunk Cross Exhibit 4 will be marked and entered into the record as hearing Exhibit 19.
Thank you, sir. All right. So briefly, the date of this order, would you accept, Mr. Strunk? And I don't know if you've reviewed it recently, but it was October 11th of 2017. You see that there?
Yep.
And so this order came out after the order that you cited for the proposition that the North Carolina Utilities Commission rejected Duke's position on the methodology to be used. Would you agree with that?
Yes, the rejection came before this. That's correct.
Okay, and you didn't cite to this subsequent order in your testimony, correct?
Yes, and the reason I didn't cite to it was because the South Carolina Commission hadn't yet done anything with this order, or with the methodology. What was implicitly approved by the South Carolina Commission was what I relied upon in my testimony. And that's why I didn't refer to this, because it hadn't affected anything in South Carolina at the time that Cherokee and DC started negotiations.
Okay, and we'll get to the implicitly relied upon in a minute, but and you were a witness in this case. You recall that, sir?
Yes, I do.
Okay, so you were aware that this order was issued and presumably aware of the findings and conclusions of the North Carolina Utilities Commission that were set forth therein. Is that fair?
Yes.
Okay. And so I'm going to refer you. Are you familiar with the findings of fact generally? And this is the statements and conclusions of the commission on the issues of the controversy in the case? That's generally what findings.
Yeah, that's generally what findings of fact are. So
I'm not trying to trip you up there. I just want to point you to on page 6 of the order. This is finding of fact number 5, and it says for non-renewable QFs, when calculating avoided capacity rates using the peaker method, it's appropriate to acquire a payment for capacity in years of utilities IRP forecast period. Integrated resource planning forecast period when a capacity need is demonstrated during that period. However, providing a levelized capacity payment over the term of the contract is a reasonable means of implementing this capacity payment. So would you agree with me, Mr. Strunk, that in 2017, the North Carolina Utilities Commission took the position that for non-renewable QFs in this finding of fact, and we'll get to cogeneration facilities like Cherokee in a moment, that it was appropriate to use a methodology where the utilities calculated avoided capacity rates based on the first year capacity need identified in the IRP, and then levelizing that capacity rate as DEC did when it provided Cherokee avoided cost rates in October of 2018. Would you agree with that?
Yeah, this was a different conclusion than they had come to prior.
Right, based on a different IRP and different facts and circumstances, but this was closer in time in 2017 to when Duke provided the avoided cost rates to Cherokee in the fall of 2018, correct?
Right, but what is ruled on in North Carolina doesn't govern what happens in South Carolina.
Well, I struggle with that, Mr. Strunk, when you're telling the commission that they implicitly accepted what happened in North Carolina in a 2-page order where they didn't have a hearing and fully vet the methodology, and they just told Duke to negotiate with QFs. And you're saying that controls the methodology Duke should have used, but the subsequent North Carolina order has no relevance to the issue. That just doesn't.
Objection, Your Honor. Objection, Your Honor. Mr. Briceford has bundled a lot in. He's kind of characterized things of what the commission, North Carolina Commission, did or didn't do. He's bundled 3 or 4 different things in, and I'm not sure what the question is here, but he appears to be testifying at this point. So I'm sorry, I just need to object to that.
Objection sustained. Attorney Bryceworth, if you would just ask your question, allow the witness to answer the question, and move on.
Yes, sir. So, Mr. Strunk, I'll try to reframe my question again. You would agree with me, sir, that the order 2016-349 that we went through earlier this week did not establish a methodology that the companies were required to rely upon in calculating avoided cost rates. Is that correct?
That's correct. It accepted what had been put in North Carolina in the docket E100 sub 140.
So in that context, you're asserting there was some relevance to what the North Carolina Commission had determined to be the methodology that Duke should follow 2014 to 2015, correct?
No, I'm not saying that at all. I'm saying that at the time of the September 2018 commitment letter from Cherokee to Duke, the applicable order, the most recent order on avoided costs from the South Carolina Commission was a 2016 order.
Which implicitly relied upon a prior North Carolina order.
That's correct. Yeah.
Okay. But you didn't take into consideration the subsequent North Carolina order that could have informed the methodology that Duke applied at the time to calculate avoided capacity value.
Well, I had reviewed this order. I've seen this order. As you noted, I was a witness in the case. And, you know, the issue there was they were getting a lot of solar QFs that didn't provide a lot of capacity value. So they had to take another look. And as North Carolina has one of the largest QF programs in the country, they're dealing with substantial megawatts from intermittent must-take resources that they have to integrate into their systems.
Okay, and so this was an IRP-based approach to quantifying avoided capacity value, just like Duke used in September 2018 for Cherokee, correct?
That's correct.
And the methodology that the North Carolina Commission approved in 2017 was the same methodology that the South Carolina Commission approved in 2019. Would you agree with that? We went through Order 881A earlier in the week.
Insofar as it determines, as it relates to the first capacity need date and how that determines QF avoided capacity costs, yes.
Okay, very good. And just for one point of, sorry, just to make sure I get this clearly in the record. All right. And I mentioned in the finding of fact, it was focused on non-renewable QFs, but if this is the discussion conclusion section, which I'll submit at page 48, is the North Carolina Utilities Commission's findings and conclusions. It also, I'll read the language here, Commission determines the avoided capacity payment methodology is also appropriate with regard to the standard offer to purchase available to QFs that are not small power producers. So that would then extend this to cogeneration facilities. Would you agree with that?
That seems to be that. Yep.
Okay. So if you're not a small power producer under PERC,
you're a cogen, right?
Yes, sir. Okay. Thank you. All right. So that then responds to the testimony that the North Carolina Utilities Commission had rejected this methodology in 2014, when in fact in 2017 they had accepted it, which is what the sub 148 order we just walked through established, right?
Objection. I think you just testified as characterizing what these orders. You should just ask Mr. Strunk just to break that down and ask what his impressions of that order are. I believe Mr. Riceworth just went over the line there and was testifying.
I think I said right at the end, or correct, or would you agree with me, sir? Which, Mr. Strunk, would you agree with me?
There was a lot in those questions. If you could take them one by one, I'd appreciate it.
Sure. Returning to your testimony at page 15, line 2, you said that it's premised on the assumption of zero capacity credit that the NCUC had rejected. We just walked through that's correct? we just walked through the sub 148 order, which was the most recent order of the North County Utilities Commission prior to the time that the avoided cost rates for Cherokee were calculated. And would you agree with me, sir, that the North County Utilities Commission, in fact, approved the same methodology that Duke used in 2018 to calculate the avoided capacity value for Cherokee?
Tying it to the IRP capacity need date, yes.
And that was the same methodology that this commission subsequently approved in the first Act 62 proceeding in 2019, correct?
That's my understanding, yes.
Thank you. All right, so moving on to line 3, you say, and we're at the end of line 2 onto line 3, and that this commission also implicitly rejected. And then you've got a footnote towards the end, footnote 31, which says, and I'll just read it in the interest of time, although prior commission orders had permitted regulated utilities in South Carolina to apply zero capacity compensation to QFs in periods when the host utility had excess supply, the commission's decisions in order number 2016-349 adopting the NCUC result implicitly went against this principle. So to be clear, order 2016-349 on its face did not approve a methodology. You say it implicitly went against this principle, but it didn't dictate a methodology that the companies shall apply in calculating avoided cost rates for large QFs, right?
No, the direction that that order gave was that the utilities were supposed to negotiate rates with large QFs.
Right. And so in terms of the time frame in which the Duke companies were developing the avoided cost rates for Cherokee, your point was that the most recent order of the commission had not yet adopted what Duke believes, and I think you used the words later, that Duke prejudged what the commission's ultimate outcome would be, this issue on the first year of a need approach to avoided capacity value. Is that correct?
That's correct. That's my rebuttal testimony.
Okay. I'd like to introduce one more hearing exhibit, if I could, please. All right. Mr. Strunk, I'm sharing with you what's been pre-marked as Strunk Cross Exhibit 2, which is a table that I have developed with some assistance that is intended to summarize the pertinent parts of 3 South Carolina Commission orders that address avoided cost issues. And so my question to you is, in your footnote 31, you say prior commission orders had permitted regulated utilities in South Carolina to apply zero capacity compensation to QFs in periods where the host utility had excess capacity supply. What orders were you referring to when you added that footnote?
Sir, before you respond,
I would just ask Mr. Vice to give Mr. Strunk a chance to review this document that he's never seen before, that Mr. Briceford said he prepared himself. I would just ask that Mr. Briceford give Mr. Strunk adequate time to review it.
That's fine, sir. That's fine. The witness does have time to review it, and while the witness is reviewing the document, Attorney Briceford, if you would enlarge that document for us. Thank you, sir.
Yes, sir. And I wasn't actually starting to question him on the document, and I was trying to focus on what he cited to in his testimony in the first instance before getting to the document, which is both a summary chart that I did prepare, but also a compilation of the 3 orders that are cited in the chart, and I think more accurately quoted in the chart, one of which is the order 2019-881A that we spent a lot of time earlier on in the week. So
I'm ready to answer your question, Captain.
Okay, thank you, Mr. Strong. So returning to your testimony, footnote 31, you say prior commission orders had essentially followed this first year of capacity need or zero capacity value methodology. What commission orders were you citing to or recognizing in that statement?
So again, you're putting words in my mouth. I said applied zero capacity compensation. You said applied the first year of capacity need date. So that, please, when you refer to my testimony, I'd appreciate it if you could use the words that I used.
Yes, sir.
I had looked at the order that you cite on the first row of this table. I had not seen the order that you cite on the second. And so I was leaning more on the first order.
Okay, and so the first one, and I can go to the actual pages of the order itself, if that would be helpful, but I would submit to you and to your counsel that this is a summary, a quotation of that order that says that capacity value would be zero in those circumstances. And so this was a 1985 avoided cost proceeding, and this was specific to South Carolina Electric and Gas. Is that your recollection of the order that you were citing to and referring to in your testimony?
Yes, and I just say it is useful to go to the actual text of the order. I think it's quite dangerous to take statements out of context without.
Absolutely. Let's go to the order. Make sure you got the full.
Chairman Williams,
Commissioner Caston.
I'm sorry to interrupt, but I really can't see these things that well. If you could blow them up some, that would be helpful.
Yes, sir.
All right, so we've established a couple of ground rules. Let's make sure we get these documents blown up so everyone can see them. And then let me say this. I know this is a contentious case, but if the lawyer would ask the question and pause and allow the witness to answer the question and pause and then allow the lawyer to answer a follow-up question. Is that fair? Yeah, we're having a hard time understanding you, both of you. Thank you.
So, Mr. Strunk, is there anything that you would like to review, or does the review of this page help you refresh your recollection? I don't want to take anything out of context here.
Yeah, no, I just think that the quote that you have highlighted needs to be interpreted with other information that is on that page.
Attorney Bryceworth,
Yes,
is
sir.
it possible to enlarge the document? Thank you, sir.
Yes, sir. Okay, Mr. Strunk, I don't. If you'd like to review the order in detail, I'd be glad to allow you additional time to do that. But I think the proposition I was establishing was that I understood you to say that in developing your testimony, you discovered and relied upon that 1985 order, for the statement you made in footnote 31. Is that correct?
Yes, that's correct. And I guess the reason I thought it was important to show the whole document was because there was a very specific case for that utility at that point in time. The commission had recently excluded some of the assets from SC DN's rate base, and had found that those assets should be excluded on a prudence basis. And so SC DN at that time was not even recovering the costs of its own capacity, all of its own capacity. So I think that's important context for the commission's findings in that order. And that's the only reason I asked you to show the full order.
No problem at all. But to be clear, you did not, you weren't referencing, you did not discover, that didn't inform your testimony, this 2018 order, which was also a SCNG fuel case order where avoided costs were addressed, and the methodology that the commission approved at that time was also assumed and avoided capacity costs for its PR1 and PR2 rates, which I would submit to you were at standard offer and his large QRFs rates at the time to be zero. Is that correct?
That's what it says, and I'm sure it says that in the order. If you I trust that you've copied it correctly. I think there is the end of the sentence says, in the absence of a viable alternative proposal being presented by any other party. So it sounds like there wasn't many other parties putting in different opinions in that case. So that's all I can draw from the quote you have there.
Okay, and I appreciate you haven't reviewed this order in detail, but would you accept, subject to check, that it was issued in May of 2018?
Yes, that's correct. It was in the context, as you say, in the annual review of base rates for fuel cost.
Okay, thank you.
It was not an avoided cost docket.
And would you accept, or do you know whether at this point in time, prior to Act 62, avoided cost rates and issues were considered in fuel cost proceedings in South Carolina?
It certainly seems to be the case based on what you've presented, yes.
Okay, so in November of 2017, the North Carolina Utilities Commission recognized the methodology that Duke applied, at least for that state, as accurate and appropriate. And I think we talked about that a moment ago. And in May of 2018, the South Carolina Public Service Commission, in its review of Dominion's, or SCNG at the time's, avoided capacity costs, recognized that setting that rate at zero based on the circumstances was reasonable. So would you agree with me, based on that recent history, that it was reasonable in October of 2018 for the Duke companies, I guess DEC specifically, to use a methodology that recognized the first year of capacity need based on the IRP as an appropriate methodology to calculate the avoided capacity rates for Cherokee?
No.
Okay. And just we went through this order the other day, but just to be clear, this is the Order 881, which followed and established the standard offer rates for all QFs from November 30th of 2018 forward. Do you agree with that?
Yes, we went over that on Monday.
Okay, and so we went over this language that established the methodology the commission approved, which was supported by ORS in that case. And I think this is the language we talked about, was reasonable and transparent. It was based on witness Ori's testimony at the time. You recall that?
Well, that's what it says in the quote you've presented.
Okay. All right. Mr. Strunk, just one other issue. And Mr. Chairman, I apologize. Did I ask this to be accepted into the record as a cross-examination exhibit?
No, sir, you did not.
Yeah, I would object. I guess I would object, Your Honor, to the extent that a chart prepared by Mr. Briceword, referencing excerpts from orders that he can freely cite to in his briefs. It almost as if Mr. Briceword is submitting testimony into this record. So I don't see why it needs to be. It's like a demonstrative exhibit. I don't think it should be entered into the record. He can cite to those orders as freely as he wants in his brief. I don't see the chart having any legitimacy as a point of evidence in this proceeding.
Well, I guess I would say the exhibit is both the summary chart itself, quoting from these commission orders, as well as the sections of the orders that follow that demonstrates the methodology that the Duke companies used in September of 2018 was consistent both with the prior orders of this commission and subsequent orders of this commission. So I would ask that it be made an exhibit and entered into the record.
I continue my objection, Your Honor. He can freely cite to all those quotes and things in his briefs, but the chart shouldn't be given some freestanding legitimacy as evidence in this record, since it was prepared by counsel and submitted after their testimony filing date. So this should not be evidence in this record.
Sustained.
Very good, sir.
Thank you, Ron.
Move on.
Thank you.
So just a couple more questions for you, Mr. Strunk. During your testimony on Monday, you were answering some questions from the chairman, and he was asking about the cost to customers. And if I heard you correctly, the all-in cost under your proposal is $47 per megawatt hour for both energy and capacity. Did I get that right?
Right, and that was based on, I believe, the first 4 months of gas prices. It was looking at recent gas price curves. Obviously, the all-in cost to DEC under our proposal is dependent on gas prices.
But the all-in cost, the total cost to customers under your proposal, which you submit as a reasonable representation of DEC's avoided cost, is $47 a megawatt hour. Is that right?
So what I think, again, your characterization isn't very nuanced or precise. What I've testified to is that the $110 per kilowatt year, which, inclusive of start costs, is a 24% reduction on the rate that customers are currently paying. So if my proposal is adopted, the cost that DEC is going to pay to Cherokee for capacity and start costs are going down by 24%. There's a rate decrease. It's not a rate increase. And what Duke is saying is that, guess what? We actually think our avoided costs are much lower. And as we can see in the responses to interrogatories, the way that DEC has sort of modeled things is disadvantageous to Cherokee. DEC suddenly in its 2021 offer has switched the gas hub off of which the Cherokee gas price is in the modeling is referenced. And it's now using Transco Zone 5, which is a higher price than Transco Zone 4, which is the gas price referenced in the contract. So I'm saying that the rates to Cherokee should decrease by 24% on it for capacity and start costs, whereas DEC is proposing rate decreases of nearly 50%.
Okay, so I'm not sure you answered my question, but your point is it would be a savings for customers relative to the 2012 PPA rates, which we all agree are too high, of 24%. Is that your testimony?
Objection to counselors testifying that we all agree are too high. I object to that part of his question, Mr. Chairman.
Mr. Strunk, if your testimony is the rate you're proposing is 24% below the current PPA rates, and Duke's testimony is that it's closer to 50% below the current PPA rates, would you agree with me that the current PPA rates are too high?
Yes, it's my understanding that both Cherokee and the Duke operating companies understand that the rates should be reset and reflective of either avoided costs. It's Cherokee's position that they should be 2018 avoided cost. It's the Duke company's position that they should be current avoided cost.
Okay, and just one more time, this $47 a megawatt hour that you threw out there on Monday, what does that represent?
That represents the cost to DEC's customers at the gas price that has prevailed recently, if the rate is set at the level that Cherokee proposes based on the 2018 LEO.
Okay, so to say it a different way, that $47 per megawatt hour is Cherokee's representation or your calculation of what the avoided cost rates would be that customers would pay. Is that accurate?
Well, so that's, again, as I clarified just a minute ago, that's based on current gas prices. As if that gas prices decline, those all-in rates would be lower. If gas prices increase, those all-in rates would be higher.
Okay, and so it's based on current calculation of avoided cost. What I'm showing you here, Mr. Strunk, are you familiar with Mr. Snyder's testimony in the case?
Yes, I've reviewed it. Testimony.
Okay. And do you recall on page 33, he had a section that was focused on the decline in avoided cost since 2012?
Yes, that's what I see.
Okay. And were you here for his discussion of his figure 2 yesterday?
Yeah, he said it was from a prior proceeding. That was my my recollection. It doesn't clarify whether he's, there's no labeling as to whether that's sort of combined capacity and energy or just energy. So I don't know how exactly to interpret it, but I did hear his testimony on it.
Okay, and so you see the citation here that this was developed by the North Carolina Utilities Commission public staff. And I think we talked about it yesterday. It's the annualized 10-year avoided costs projected out based on the point in time that those avoided costs are calculated for the 3 regulated utilities in North Carolina whose avoided costs are subject to oversight by the North Carolina Commission, DEC, DEP, and Dominion Energy North Carolina. Do you accept that?
Yeah, but based on sort of the levels that we're seeing there, it looks like it's an avoided energy cost because if you look at the 2018 offer and you try to line it up with this graph, it looks like an avoided energy cost.
I think that is the issue that we're discussing here is what are the appropriate levels of avoided costs to be established. And I guess the commission, I don't know that it's in Mr. Snyder's testimony, the commission can determine whether this is full avoided cost or just an avoided energy cost. But would you agree with me that the avoided cost rates presented here are well below the $47 for 2018 through 2020 that you've calculated in your proposal?
So that's a very, if it's only an avoided energy cost, you're talking apples to oranges. But I have 2 comments there. One that obviously that doesn't include the capacity value. And the second comment is that, if you were to extend that over to the right to see what's happened since then, gas prices have been ticking upwards. So you would start to see an increase over to the right on the avoided energy costs. And we also heard from Mr. Freund that the capacity value for Cherokee in the 2021 offer was about $36 per kilowatt year, which is going to raise that number significantly.
So Mr. Strunk, and just to be clear, I appreciate that you were not in this North Carolina proceeding and you don't have the context for this, but you are making an assumption, are you not, that this is just an avoided energy price? Is that correct? You don't have any basis for that conclusion?
Well, the only basis is if I try to line up the 2018 number with the quote that Cherokee got in October 2018, and it looks like that's only reflecting energy.
Well, isn't that this says total annualized 10-year avoided costs? Would you accept that the total annualized would presumably include an avoided capacity and avoided energy value?
Well, I would accept that that's a reasonable interpretation of total, but what we've heard on the record and what we have, the evidence that we have on the record is that to the energy value that Cherokee got quoted in 2018, if you were looking over 20 years, over 10 years, Mr. Freund testified that you'd have to add capacity value because there was a need out in the 28 to 2030 period, and that capacity value he testified would be $15 per kilowatt year. So this does not, based on what I'm seeing here, it does not square with that. With Mr. Freund's calculations and with the offer that DEC, this squares with an energy only.
Okay, well, I appreciate we don't have the facts of whether this is an energy only rate or an energy and capacity rate, and that Duke doesn't have another witness to put forward to clarify that for commission. But you would agree with me that the red line in 2018 is substantially below what you've calculated as the appropriate avoided cost rate for Cherokee. This is probably $32, $33, whereas you are proposing a $47 per megawatt hour equivalent rate in your $110 calculation. Isn't that correct?
So, I just can't agree that this has any relevance. If we look at the exact terms of the offer that Cherokee was quoted $33.50 per megawatt hour, which is 3.35 cents per kilowatt hour in October 2018. And that was for off-peak energy. So this is completely inconsistent with Cherokee, with Duke's quote to Cherokee. It's reflective of the off-peak energy value. The peak energy value was 40.71 or 4 cents, almost 4.1 cents per kilowatt hour. So that would be way above what we're seeing in the red line. So this is not a reasonable representation of anything that's relevant to this proceeding.
Okay. No further questions, Mr. Chairman. Thank you, Mr. Strong.
My pleasure.
We're in recess until 3:20.
Thank you, Mr. Chairman.
Good afternoon, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina. We're here in docket number 2022-63E. Let's take roll. Present in the hearing room are Vice Chair Belzer and Chairman Williams. Joining us virtually, we have Commissioners Powers, Thomas, Caston, Irvin, and Williams. ORS, do you have any cross-examination?
No questions for this witness from ORS. Thank you, Mr. Chairman.
All right, Commissioner questions for this witness.
Chairman Williams, briefly.
Commissioner Caston, the floor is yours.
Okay. Good afternoon, Mr. Strong.
Good afternoon, Commissioner.
I really am trying to understand all this. So,
It's very complicated.
Yes, sir, it is. So, is Cherokee's argument that the avoided cost applicable in September 2018 is what the contract should use? Is that the argument or part of the argument?
So it's my understanding of Cherokee's position that Cherokee is looking for an avoided cost calculated as of the date of its September 2018 LEO. And obviously Cherokee does not agree that Duke had reasonably calculated that avoided cost as of that time.
Okay. So what I'm trying to get my head around and with all the different charts, and I think the questions you just had from Mr. Bryworst, it's that avoided cost in September 2018, whatever that is, and that is part of the debate and discussion. And does that avoided cost include the avoided capacity, or just the avoided energy? Is that correct? Is that
That's exactly right. And in my testimony, I've leaned on, because these are very controversial issues, I've leaned on decisions that were approved by the commission. What Duke is seeking to lean on is, these updates, right? And sort of its position of avoided cost at any point in time. And when you heard Ms. Hip from ORS, she said, okay, we reviewed the assumptions. We reviewed all the assumptions in the avoided cost docket, but she doesn't review the assumptions that go into the updates. And there's been no scrutiny of the assumptions. And I think that's one of the big issues, because they require a lot of discretion on the part of whoever's doing the modeling.
okay? Well, if I understood, I think it was Witness Snyder, when we talked about zeros in the early years on the avoided capacity, as I understand it, that avoided capacity, which goes out to 2026, 2028, whatever the debate is, it's levelized over the entire length of the contract. Is that correct?
That's correct.
Okay.
And just to clarify, that's how Duke does it, and that's how the commission, that's the most recent adoption by the commission in its end of 2019.
Yes. Yes, sir. Thank you. I think Witness Snyder also stated, and this was just touched on also, I think, looking at that chart, but whether the chart's accurate or not, Witness Snyder stated that the February 2020 avoided cost rates are higher than the February 2018. Or I guess that the February 2021 avoided cost rates are higher than the February 2018. You agree with this?
No, I don't agree with that. As I was responding to Counsel for Duke, the February 2021 avoided cost raise a lot of issues. again, the modeling behind them has not been subject to scrutiny. And when we looked at it with respect to there were a number of assumptions that looked a little bit worth further scrutiny. For example, I talked about, in response to counsel for Duke, I talked about how the modeling of the gas price for Cherokee and that underlies the offer was based on a different gas hub than had been used for Cherokee previously, and a different gas hub that had been referenced in the contract. And that gas hub that was used in that modeling tends to have a higher price, and the use of a higher gas price would tend to depress the energy value that Cherokee provides to the Duke system. So that's one area where the assumption seems off. And then also, that offer was based on gas prices as of August 2000. So now we're looking at gas prices that are about a year stale. So I think there's quite a bit of it's very difficult to just say, okay, that's a reasonable avoided cost forecast. That's why these avoided cost hearings are so contentious, and that's why the commission has to typically adjudicate a result, because parties think that different assumptions are reasonable. So when I look at those two offers, right, the energy value for Cherokee has come down substantially, I guess, in Duke's modeling. So that's what but the capacity went up. So I don't think we have a clean evaluation of the two offers that could say definitively that one's better than the other. I was focused on 2018 because that's the data that we have.
And earlier, did I understand you to say that you looked at the last 4 months of gas prices, just those 4 months?
Right. So I looked at those on a spot basis, meaning what was the spot cost of gas. What you have to do when you're doing a rate like this for Cherokee under a term contract that's going to cover many years in the future, whether that's 5 or 10. You have to look at the forward gas prices. So that would require another analysis, and I have not done that analysis as of today or as of February 2021. But I did review what Duke had done, and I had some concerns about it.
Well, it seems like I've consistently heard through the course of this hearing that, at least from Duke, that they're required to offer the avoided cost rate, well, that's 2018 avoided cost rate that's been approved, or the 2019 or whatever. Do you agree with that?
I agree that Duke is bound by the principles of avoided costing, but in regulatory practice across the country, costing is subject to a zone of reasonableness. And so you could have a number of different utility analysts that would come back with a different avoided cost based on reasonable, each of them applying reasonable assumption. So one of the problems with this process is that there was no room for Cherokee to scrutinize or to do its diligence until this proceeding commenced and the data was produced through discovery. I would just say that there's no single avoided cost, right? We know from the scheduled PP rate that there's an avoided cost for 5 years. There's an avoided cost for 10 years, and those are two different numbers. So the characterization that there's just a single avoided cost and that there's no zone of reasonableness, and that Duke had to enter into there was a specific price that Duke was bound to enter into a contract at is the premise that I do not agree with, and it does not comport with the practices of determining a zone of reasonableness and negotiating on things like term, where term can affect the avoided costs.
Well, I thought negotiations, and I guess that's where I'm trying to kind of understand this Leo thing again. And God, I hate to even bring that up, but whether it's that stake in the ground, whether it's that moment, on the one hand, it seems like I've heard the arguments from Cherokee that, you know, and maybe Duke, it's not a negotiation, it is a commitment. So in your opinion, in September 2018, did Cherokee commit unalterably, guaranteed to Duke for that service, for that energy?
So I've looked at the September 2018 letter, and to me, my interpretation of that is that they were doing their best. There was no standard form available, but they were doing their best to tell Duke they wanted to keep selling energy and capacity to preferably DEC, but then there was some, you know, communication from Duke to Cherokee, which triggered some involvement with DEP. So my review of the documents would confirm that Cherokee did intend to sell the output. There's not much of a market in Gaffney, South Carolina for the output, and that's why when you don't have a regional transmission organization and you just have a vertically integrated utility serving retail customers, it can be difficult for QFs to find a market, and that's why PURPA created the market where the off-taking utility was required to buy the power.
Okay, well, I'm certainly no expert on contracts, and I do not have my Black's Law Dictionary that my good friend Mr. Powers allowed me to have. I don't know what the legal term for intent is, or you know, they tried. I think you said they really tried. What I'm trying to understand, Duke's assertion is that it's not a Leo because there was no firm absolute commitment that they could hang their hat on and bank on. So they may have had good intentions to do so, or they may have really worked at it. Did the September 2018 document, in your opinion, have that, not only that stake in the ground establishing that date, but that absolute commitment that Duke could count on it 100% no matter what?
So my view is that the document puts a stake in the ground, and if Cherokee had received reasonable offers from Duke, they would have proceeded to negotiate them, and then I think everything would have worked out. I started working in the power business in 1994, and I've never met a utility executive or a utility manager that wanted to do a must-take agreement with a dispatchable facility. It's just that offer in and of itself just seems, you know, so outside the zone of reasonableness. And it was done, you know, in the name of treating some large solar QF in the same way that you're going to treat a dispatchable, you know, facility that can produce the 100 megawatts of power reliably. And so I think Cherokee was naturally, you know, not happy with the types of offers that Duke was giving. Sorry.
Well, I'm not trying to paint you in a corner here, but I must be honest with you. I've not heard anything you say definitively that sounds like it was guaranteed they could bank on it. So Duke could bank on it without any expectation of it not occurring. The debate whether or not you agreed with, I guess, or Cherokee agreed with the terms or liked it or not, I get that debate. I understand it. I'm just trying to understand this stake in the ground concept. Let me ask you this. Is it possible to have a legally enforceable obligation if the QF offers the same capacity, two separate utilities? Is that possible? Have a legally enforceable obligation?
So I'm not a lawyer and I can't speak to the legal aspects, but as a practical matter, as a regulatory economist working with electric utilities on power contracting matters, I think the circumstances here, given that the entities involved operate under a joint dispatch agreement and that the representatives who are employed by the holding company of both opcos were the same people, that it's reasonable to interpret the fact pattern in this case as establishing a LEO, because Cherokee, as Mr. Hansen, I believe he testified on Monday, that Cherokee just wanted to sell its output to one of the Duke entities and was, started with DEC because that has been the off-taker for over 20 years and was sort of encouraged to talk to DEP. So in the context of the fact pattern that's before the commission, I think it's a reasonable thing for Cherokee to have done. And I don't think the fact that Cherokee was talking to both utilities through the same people should mean that there was no LEO established in 2018.
Well, it may be reasonable to Cherokee to assume that, but I'm kind of struggling to assume that because they sent two separate letters, one to DEC, one to DEP. If they were kind of doing stuff together on one company, wouldn't you just send one letter to DEP and DEC at the same time, same date?
Well, so I guess the reason they didn't, and Mr. Hansen's was a better witness on the factual circumstances, because I wasn't, I work for Near and Near as an independent consulting firm, but my understanding is that the sequence of events was such that first Cherokee looked to DEC, and then there was this apparent capacity need at DEP, and so that's why they went to DEP. I guess when the first letter was sent, I don't think that Cherokee might not have known that DEC was going to take the position it was taking on capacity need, and that a capacity deal with DEP might have been better. All of this is really better covered by Mr. Hansen.
I understand that, and just will follow up with that, but at least I'm of the opinion, based on what I understand, that Duke Energy Carolinas and Duke Energy Progress are two separate utilities. We have an avoided cost hearing, I think, coming up next week, which is distinctly DEC, DEP, and then following that will be Dominion. So we certainly, at least I view it that way based on my understanding of the way it's set up. And I'm still kind of struggling to understand that if that is the case, if it is a legally enforceable obligation, and I understood you just then to say that, they didn't like the way things are going with DEC, so, they were looking to see what DEP might be interested in. I'm not sure how DEC could interpret that. I'm not sure that could be interpreted either as a legally enforceable obligation if it's not really obligated. Whether or not you agree with this number or that number. Anyway, do you understand my confusion or concern?
Yeah, I understand your concern, and I think, you know, you're right to separate the issues, right? One is the issue, was the LEO established? And then the question is, okay, if the LEO was established, what's the appropriate rate? So, you know, I've given sort of my view, my high level view of the LEO issue, but I think Mr. Hansen is best established to talk to the specific circumstances of the letters and what happened between the two companies. But you're absolutely right to separate those two issues, and my testimony is really focused on the rates.
I understand that, Mr. Strong. Thank you so much. I appreciate it.
Thank you, Commissioner.
Questions from commissioners? Hearing none, redirect. All right, sir, you may step down from the witness stand.
I do have, I'm sorry, Mr. Chairman, I do have some redirect.
All right, please go ahead.
Okay, thank you, Mr. Chairman. Mr. Strunk, Mr. Gaston was asking you about Mr. Snyder's statement that the rates they offered in February 2021 were better than the Cherokee was entitled to in 2018. Do you agree with that? And I'd like you to focus on the capacity, especially the capacity rates offered between the two, especially what was being offered or not offered in 2018.
So in 2018, Duke was not offering a capacity rate. But I do not agree that the 2021 offer was higher than the rate that should have been applicable to Cherokee as of September 2018.
Mr. Bright, showing you a chart or I guess a graph that was from Mr. Snyder's testimony. Is there anything in that chart or anything that made you reinforce or add any support or different opinion on whether Duke was entitled or what Duke was appropriate for Duke not to offer any capacity payments in 2018?
No, that chart seems very disconnected from the offers that were made by Duke as I responded to counsel for Duke. The rates, the energy only rates were significantly higher than the red line shown in that chart. And that chart does not look to reflect the rates that you know are at issue in this proceeding.
Thank you, Mr. Strzok. Now, there's been a lot of talk about different IRPs, and I just want to be real clear. Mr. Briceford asked you about different IRPs and IRP orders. Do you believe that the 2018 IRP was an appropriate basis for Duke to rely on in determining whether it had a capacity need or not?
Not at that time, right? So at that time, the 2018 had not been reviewed or approved by this commission or the NCUC. There had been prior IRPs that were approved by the NCUC with earlier capacity need dates. So I don't think that, you know, the whole problem is that the complexity of the assumptions going into those models and the findings in the IRP is so great and so subject to debate and differences of reasonable differences of opinion that it's important that they be resolved through a regulatory approval. And at that time, what Duke was offering to Cherokee based on 2018 IRP was a worse rate than would have been applied had it been looking at any other more recent approved IRPs, and was a worse rate than what had been approved by the commission for the Schedule PP small QFs.
So is it your, excuse me, is it your view that Duke was exercising discretion in its modeling assumptions for the different rates that were offered either in 2018 or subsequently?
Absolutely. Anytime there's a refreshing of a rate, that means that a whole new set of assumptions, new gas curves, and potentially new load forecasts, new retirement dates from new depreciation studies, they can all affect what comes out of both the IRP modeling and the avoided cost modeling. And the only vetting that's really done is in the docketed proceedings that are before the commission. So there's a lot of discretion in what goes into an offer that's not based on an approved IRP or an approved set of assumptions that establish rates for QS.
Mr. Strunk, there were some questions about page 12 of your testimony and a 2016 order of this commission. And there's been different statements made about you should negotiate rates, or we have absolutely no discretion to negotiate rates. What is your understanding, if you have any, regarding from a policy perspective, with regard to this commission, its 2016 order or other orders that you're aware of, whether Duke has the ability to negotiate rates that in connection with the LEO?
Oh, Duke had a mandate from this commission based on the 2016 order in the avoided cost date to negotiate any contracts with large QFs, and that we all heard Mr. Keene testify, and some of the things he said that they would typically negotiate, and include the term of the contract, whether it's 5 years, 10 years, 7 years. And that's consistent with what I've seen. And that negotiation then in turn affects the rate. So Duke had a specific mandate to negotiate. And what we saw in the documentation, what's on the record here, is a take it or leave it contract that's based on an avoided cost rate that Duke was unwilling to negotiate.
Thank you, Mr. Strunk. There was also, Mr. Bryceworth was referring to a $47 per megawatt hour rate in your testimony, and it seemed to be, he was saying that was part of the $100 rate. But in reading your testimony, I just want to make it all clear, the $110 and the capacity and energy components seem to be in kW year. So were his questions to you, did you understand them to be referring to your capacity component of $47 per kW year, or was it something different he was asking about?
My understanding was that he was asking about a figure that is not in my pre-file testimony, but that I had presented in Monday's hearing, and that was to convert the dollars per kilowatt year rates into a dollars per megawatt hour rate. That on an all-in basis, including start costs, fuel costs, et cetera.
Thank you, Mr. Strunk. Now, there was also questions about whether you were being treated or discriminated, Mr. Bryceworth was asking, with regards to other large cogens. Okay? And on redirect after your direct testimony, we focused on a PURPA reg regarding what ability does the state commission have to look at other factors, other attributes that differentiate resources from another. Do you recall that?
I generally recall that discussion, yes.
Okay, if we could just put that up on the screen real briefly, because I think it's relevant to Mr. Bryceworth's questions about potential different conduct or discriminatory conduct, et cetera. So we'll put 304E up, if we could. Okay, let's scroll up just so we have, the commission can know where this comes from. We talked a lot about 292.304, certainly in my cross-examination of witness Bowman, but with respect to your statements, let's scroll down. This is rates for purchase, 292.304. Let us know if you need this blown up more. But we're going down to E2. Do you recall looking at this before during your redirect, after your direct testimony, Mr. Strunk?
I do. Can you refer me again to which sub number and sub heading we're referring to?
Well, referring to E2, and this states the following: to the extent a state regulatory authority or non-regulated electric utility does not set energy capacity rates pursuant to E1 of this paragraph, the following factors shall, to the extent practicable, be taken into account in determining rates for purchases from QF. And they have a number of different factors, and the ability, this is 2.2IA, the ability of the electric utility to dispatch the QF. Do you recall that?
Yes. Yes,
Okay.
that's an essential.
And could you just describe why that factor is apparently able to be taken into account, why that might be a differentiating factor between a dispatchable QF and a non-dispatchable?
Yes, and you heard, the commission heard Mr. Snyder's testimony. The off-taking utility does a valuation of the power coming from the qualifying facility. And that valuation will be very different for a dispatchable resource than a non-dispatchable resource. And the offer that was made in October 2018 did not incorporate any analytical valuation of the dispatchability of Cherokee, and in that regard was not consistent with the directive here. However, over time, after Cherokee filed its complaint, DEC did engage in some modeling where they explicitly sought to value the dispatchability of Cherokee. Now, I had some concerns about how they did that and some of the assumptions, but it was clear that the February 2021 offer was based on an analytical technique that was consistent with these regulations. And the earlier offers, all the must-take offers, were not.
Was it, when you're talking about the different offers made, I'm assuming you're talking about, does that include Duke's October 2018 offer, where there was zero capacity, or are you talking about the subsequent offers, Mr. Strong?
I'm talking about all of the written offers that were made before Cherokee filed its complaint.
So there was no commission review of those offers to the best of your knowledge?
That's correct.
Yeah. So Duke in October 2018 was offering $0 for capacity. In your testimony, you were proposing what capacity rate and on what basis? And that'll be my last question.
So I was assuming a capacity rate of $47 per kilowatt year, and that capacity rate was based on the Schedule PP rate that had been approved by this commission in its 2016 avoided cost order.
Thank you, Mr. Strunk. Mr. Chairman, I have no further redirect from Mr. Strunk.
All right, sir. You may step down.
Thank you, Mr. Chair.
Please call your next witness.
Thank you, Mr. Chairman. Cherokee calls Mr. Nathan Hansen. Mr. Hansen, you're still under oath, I believe, or are we swearing again? I'm sorry, Mr. Chairman.
You're exactly right, Attorney Pringle. He is still on their oath.
Okay. Thank you, Mr. Chairman. Mr. Hanson, if you would, please state your full name and address.
Nathan Hanson, my business address is 1700 Broadway, New York, New York.
Okay, by whom are you employed and in what capacity?
LS Power Development. I'm a Senior Vice President of Commercial and Energy Markets.
Okay. Are you the same Nathan Hanson who filed and presented direct testimony earlier this week?
I am.
Did you also cause to be pre-filed rebuttal testimony consisting of 17 pages in question and answer format?
I did.
Do you have any additions, deletions, or changes to make to that pre-filed rebuttal testimony?
No, I do not.
If I ask you all the questions that appear in that pre-filed rebuttal testimony, would your answers be the same?
Yes, they would.
Mr. Chairman, at this time, I'd like to ask that Mr. Hanson's pre-filed rebuttal testimony be read into the record as if given orally from the stand.
Mr. Hanson's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
Mr. Hanson, did you also attach 3 exhibits to your rebuttal testimony?
I did.
Can you identify those exhibits very briefly?
One is designated network resources for Southern Company.
Okay, exhibit 1.
One is designated network resource list for existing SPP NITS customers.
Okay. And what about the third?
Schedule of P&M designated network resources.
Okay. Mr. Chairman, I'd like to ask that exhibits 1 through 3 of Mr. Hanson's rebuttal testimony be marked for identification and entered as the next hearing exhibit.
Attorney Pringle, give us a couple of minutes to get the documents out in the courtroom.
Oh, of course.
All right. Attorney Pringle, could you identify those documents for us one more time? Attorney Pringle, I think you may be muted.
And I'm sure I'm much preferred that way. My apologies. Exhibit 1 to Hanson rebuttal testimony is Southern Company's designated network resources for 2021.
Okay, and Exhibit 2?
Exhibit 2 is a schedule of P&M designated network resources, October 6, 2020.
Okay.
And Exhibit 3 is designated network resource list for existing SPP NITS customers.
All right, sir. Hanson rebuttal exhibits 1 through 3 will be marked as a composite exhibit and entered into the record as hearing exhibit 20.
Thank you, Mr. Chairman. Mr. Hanson, have you prepared a summary of your rebuttal testimony? And if so, please present it to the commission.
Sure. I'm just trying to move this along. My rebuttal testimony was really responding to testimony of the company's witnesses in this case. At issue, it really went to discuss the establishment of a legally enforceable obligation. It further discusses my view of, I guess, examples of how Duke did not engage in meaningful negotiations with Cherokee pursuant to the various offers that were applied. And then it discusses briefly this concept of transmitting power to DEP under a qualified facility contract and how that could be done efficiently through the designation of a designated network resource by DEP of the Cherokee facility versus having to acquire point-to-point transmission, which is significantly more expensive. With respect to the legally enforceable obligation, we filed the only form available to create a notice of commitment to Duke by modifying the below 2 megawatt form that they had available to reflect the characteristics of the Cherokee facility, which Duke knows very well because they dispatch the plant under the current PPA that we're operating under. And even before we got pricing from Duke, they ignored or rejected the establishment of a LEO. And for various reasons, we're not sure, but it was our commitment at that point in time to try to negotiate a successor PPA with Duke Energy Carolinas, as we have been serving their customers for over 22 years. And with respect to not engaging in meaningful negotiations, in each case when we received offers from Duke with respect to avoided cost contracts and the rates associated with them, Cherokee responded with questions and counteroffers at various times. And each time we attempted to commence the negotiation process, there was really no engagement on behalf of Duke. And we would be rejected in terms of, we cannot accept the rates that you offer because they're above our avoided costs. But there was no conversation about extending term or other provisions that would lead to potentially being able to close the gap between what they viewed as their avoided cost and what we viewed as an estimated avoided cost in some of our counteroffers that we made. And then even after we were directed to Duke Energy Progress because of their earlier capacity need and received the avoided cost rates from DEP, we were told that you would have to obtain point-to-point transmission, which is a very expensive transmission service that we could apply for and try to obtain under their open access transmission tariff, versus a more efficient way, and has been done around the country in other areas. DEP could easily have designated Cherokee as a network resource, and we could pay network transmission charges for that service, and which are cents on the dollar on a comparison basis to what point-to-point transmission would cost a small facility like Cherokee. So that, in light of that, we felt that there was, because of Duke's position that they weren't willing to even consider providing network transmission service and engaging in that conversation of setting that up, we felt the long-term solution here, and I believe Duke did also in subsequent conversations, that DEC was the more appropriate place to try to contract the Cherokee facility to, as that network resource, transmission was not going to be made available. Although it was communicated to us that it would have been potentially made available if it was a negotiated contract but not a perfect contract. That's a short summary of my rebuttal testimony.
Okay, please answer any questions that the parties or the commissioners may have for you.
Cross-examination.
Thank you, Mr. Chairman. This is Tracy DeMarco for the Duke Companies, and I will be very brief with Mr. Hansen, given that it is Friday afternoon, and I think at this point in the proceeding, both parties have had an opportunity to very thoroughly present their positions on the relevant issues. So, Mr. Hansen, thanks for being with us on a late Friday afternoon. I just have a very few questions for you. If you would turn to page 11 of your testimony.
Rebuttal testimony or the
Sorry,
testimony?
yes, your rebuttal testimony.
Okay.
And if I'm not mistaken, this is the area of your testimony where you discuss the designated network resources.
Page 11?
Yes, I'm looking at page 11. And I'm looking at specifically the last phrase in the last sentence where you say, it is not at all uncommon for utilities to designate QFs as network resources. Do you see that?
I'm just trying to locate it, but I presume it is. I do see it, yes.
Okay, and if you would flip to the next page, your table 2 purports to present a list of QFs that have been designated as network resources by it looks like 3 different transmission providers. Is that right?
That's correct.
Okay. And am I interpreting this chart correctly to when you say transmission provider, that column is the utility that's designating the QF as a network resource? Is that right?
Yes, that's correct.
Okay. And did you review the FERC Form 556s for these QFs before preparing your testimony?
I did not.
Okay, well, I'd like to show you just a couple of those, and I will share my screen, so bear with me for one moment. All right, hold on. And can you see, is this large enough to read? Can you see the FERC Form 556?
I see it, yes.
Okay. And before I get into the questions, Mr. Chairman, I'd like to submit this as the next hearing exhibit. This was previously marked as Hansen Cross Exhibit 1.
And Mr. Chairman, Jack Pringle, I don't want to interrupt Ms. DeMarco's flow too much. I'm not sure that those, and correct me if I'm wrong, that your cross-examination exhibits have been emailed around.
Oh, I'm sorry. My apologies. I do have an email ready to hit send, and I will send those to you right now.
No worries.
So they should be in your inbox shortly.
Excellent. Thank you.
Okay, thank you. Okay, Mr. Hansen, would you agree that what we're looking here, it says the full name of the applicant is the Coca-Cola Company. Would you agree that that tracks the name of the first QF identified in your chart?
It appears so, yes.
And scrolling down, it's got the QF number here highlighted. Would you agree that that also tracks the QF number in your chart? Okay, thank you. I'm going to come down here to the second page. And do you see here that it says that identify the utility interconnecting with the facility, and that's identified as Georgia Power? Do you see that?
I do.
And in your table 2, you have identified the utility that is designating the QF as a network resource as Southern Companies. Are you aware that are you aware that Georgia Power is a subsidiary of Southern Companies?
I am aware of that.
Okay. And would you agree that it is the only subsidiary of Southern Companies that is an electric utility in the state of Georgia?
I presume so. I can't confirm that, but I know they have 3 other electric utility holding companies, each with different state names. So I presume it's the only one in Georgia.
Thank you. And then looking at line 4C, as the FERC form asks for identification of the utility purchasing the useful electric power output, and that is also Georgia Power Company.
Yes.
So would you agree that in this case, the Coca-Cola QF was already directly interconnected into the utility that designated it as a network resource?
It's interconnected into, Georgia Power Company.
Okay, thank you. And I just want to look at one more, and I will go to, this was previously marked as Hansen Rebuttal Cross Exhibit 4. And Mr. Chairman, if I could, if you would admit that into the record as the next hearing exhibit, I'd appreciate that.
So we got Hansen Rebuttal Cross Exhibit 1 and Hansen Rebuttal Cross Exhibit 4. Do you want them entered as a composite exhibit or individually? Because I didn't enter Cross Exhibit 1.
And thank you for catching that. A composite exhibit would be fine, Mr. Chairman.
All right. So Hansen Rebuttal Cross Exhibit 1 and Hansen Rebuttal Cross Exhibit 4 will be marked as a composite exhibit and entered into the record as hearing exhibit 21.
Thank you, Mr. Chairman. And so I'd like to walk through this again, Mr. Hansen. Do you see that the applicant here is the Public Service Company of New Mexico?
I do.
And I'm going to scroll down. This one is lacking a QF number, but on the page 2, you see the facility name says Vista Solar Energy Center.
I do.
And you would agree that that is the same QF that is listed on your table 2. And I will represent to you that we got these from the FERC website and that the QF numbers match there. But that I guess I'll ask you to agree here that this is the same name of the QF listed as I think the 5th one on your chart.
I presume it is. I mean, I'll take your word for it at this point in the proceeding so we can move along.
I appreciate that. And scrolling down here, question 4A, identify the utility interconnecting with the facility, and that says Public Service Company of New Mexico.
It does.
And in your chart, you also have identified the utility designating the QF as a network resource listed as the Public Service Company of New Mexico. Is that right?
That's in table 2, yes.
That's in table 2. So you would agree that for this instance as well, the QF was directly interconnected into the utility that was designating it as a network resource.
I would say they're directly connected to the utility, yes.
Yes. And in the case of DEC, to the extent that your testimony suggests DEP should have designated Cherokee as a network resource, you would agree that Cherokee is not interconnected into the DEP network.
Yeah, I think my testimony said that DEP could designate Cherokee as a designated resource. I do agree with you that Cherokee is not interconnected to DEP. It is interconnected to DEC.
And that is unlike the 2 QFs we just looked at, which were from your chart that were interconnected into the utility that was designating them as a network resource.
Yeah, I don't know if these facilities, as you point out here, are not designated as network resources, but it appears that they are interconnected to the utility.
And you testified earlier that your chart represents that the utility had designated these QFs as network resources, correct?
That's right, based on the information I reviewed. Yes.
Okay. And I'm not going to take us through all of the QFs listed in your chart, but given that you said you did not review the FERC Form 556s for these other QFs, you would agree that you don't know whether these other QFs were already interconnected into the utility that designated them as a network resource.
I didn't review the 556 forms. No, I didn't.
Okay, thank you. I just want to move on and ask you one other set of questions. And if you would, I'm going to switch over to what was previously marked as Hansen Rebuttal Cross Exhibit 6. And this is a letter that was, if you listen to Mr. Keene's testimony on, I believe it was yesterday, there was some discussion of this document. Are you familiar with it?
I am.
Okay, and this is fair to say discusses the letter of credit that it represents Cherokee would agree to increase letter of credit totals at 2 different times in August and then in September. Is that an accurate representation of what this letter says?
Could you restate what the letter? Would you phrase the letter as representing?
Yeah, so I'm looking at these 2 bullets. And the first one says, on or before August 10th, 2021, and before DEC makes payment on the July invoice, Cherokee will increase the letter of credit to a total of $3 million, an increase of $2 million. Is that right?
That's what it says. This is a letter from Duke to Cherokee.
That's right. And the second bullet says, on or before September 10th, 2021, Cherokee will further increase the letter of credit to a total of $6 million, which is an increase of $3 million. Is that correct? You see that?
That's what it says, yes.
Okay. And if you listen to Mr. Keene's testimony yesterday, there was some confusion about whether Cherokee had agreed to these terms or whether these terms were still under negotiation. And so in the interest of transparency and just making sure everything is clear in the record, does Cherokee agree to these 2 terms set out in the bullets?
Yeah, I think that's a little, if we want to really frame the conversation to address Mr. Keene's testimony, it'd be good to step back to the first letter that we received from Duke, which was dated April 29th, and maybe walk through the history of this. On April 29th, we received a letter from Duke asking Cherokee to post $8.7 million due May 6th. And at that point in time, when we received this letter on April 29th, we have, absent the dispatch costs, so the fixed payments under the contract, because we presume if Duke is dispatching our facility, it's good for their customers. It's their cheaper alternative to actually procure energy. So just looking at the fixed payments under the contract, Duke had only paid in January, February, and March at that point, Cherokee just over $1 million. So the first salvo from Duke on this was post $8.7 million, although they've only paid us $1 million to date when they requested them. And then subsequent to that, on May 24th, they sent Cherokee a letter indicating that we were in default of the PPA. Clearly knowing there are no provisions under the current agreement to post credit above $1 million at the end of the contract, but the maximum even at the beginning of the contract was $3.5 million. So our response to that was, on June 25th, I had a call with Mr. Keene and Mr. Johnson and suggested as a way to try to put this behind us so we could get on until the commission hears the case and we determine what the solution is here. We suggested, why don't we measure the difference between what their February 10 proposal was to us, which, not that we agree that those are applicable rates, but they're out there, and what you're paying us under the current PPA, which are very small payments in the beginning of the year and larger payments in the end. We responded to that with a letter on June 25th, suggesting that we would post $3 million by August 10th. So that's where we left it. Duke then responded with this letter. which has additional credit support beyond that point in time. So that's kind of the history here. I thought it would be good for the commission to hear that. And so that's where we are.
Appreciate that longer explanation, and my purpose in putting this exhibit before you was to make sure that we were fully transparent to the commission. So it sounds like what I heard you say was that Cherokee has agreed to this August 10th, 2021 deadline to increase the letter of credit to 3 million, but has not necessarily agreed to the September 10th deadline to increase the letter of credit to 6 million. Is that correct?
That's correct at this point in time, but we do plan to post the additional credit support by August 10th as they requested.
Thank you.
And then we would probably talk to them more about the additional. Or what we suggested was to try to get us through mid-September, when we hopefully we can be through this process and there'll be direction on how we're going to move forward, and we can resolve it at that point in time.
Understood. Mr. Chairman, I would ask that this be marked as the next hearing exhibit. Hansen Rebuttal Cross Exhibit 6.
All right, Hansen Rebuttal Cross Exhibit 6 will be marked and entered into the record as hearing Exhibit 22.
Thank you very much, Mr. Chairman, and I have no more questions for Mr. Hansen.
All right, Commissioner questions for Mr. Hansen.
Chairman,
Commissioner Caston.
afternoon, Mr. Hansen.
Good afternoon, Chair or Commissioner.
If I understood Mr. Struck earlier, and I want to make sure I'm correct, if the September 2018 date is the date at stake in the ground, if I understood him correctly, he asserted that the value for the avoided cost, the rate for that September 2018, it would be the 2016 commission approved avoided cost. Is that correct?
I think what he was trying to communicate was the only adjudicated and ruled on avoided cost rates that were in effect when we established that our legally enforceable obligation was that 2016 case. So that was kind of what was approved at that point in time.
Okay. And the debate and discussion has been, assuming that date, if that date were the date, that it should be the avoided cost on that day. And I guess that is part of the debate. Well, does that mean that day, 2018, or does that mean go back to 2016? Correct?
That's correct.
Well, let me ask you this hypothetically. Would it, I guess, have been appropriate, I guess, based on Cherokee's interpretation of FERC rules and regs, etc. Say for Cherokee, if they had stuck a stake in the ground, say in 2015, and then I guess that would have applied to the 2012 avoided cost rates. Is that correct?
If that was the most recent case, yes.
So I guess that's what I've really been trying to get my head around this whole week. I guess, based on your interpretation or understanding of FERC rules and regulations, can the QF, in this case Cherokee, instead of waiting until 2018 or 2019, and the contract expires 2020, end of 2020, could they, 2 years, 3 years after the initiation of the contract, I hate to use that, stake in the ground is kind of being overused here, I know. But could they use that date to negotiate the next 10 years?
A subsequent 10 years?
Yes.
I suppose they could. I mean, our intent was not to do that. As Mr. Keene testified, in the summer of 2018, he came out and visited the plant. There were some discussions around kind of the next PPA. That's why we sent those commitment forms in September of 2018 to commence those conversations. Our whole intent, and there was no trying to game the system, our whole intent was try to secure a contract to sell power to Duke and its customers for a subsequent period beyond the term of the existing PPA. What's been frustrating is the inability to engage in any meaningful negotiations. And I would say, well, there's limited offers going back and forth. We went to DEP because they had a nearer term capacity. That didn't seem like it was going to work out because of the transmission issues I just described. So then we went back to DEC, and in September of 2020, DEC made an offer, in a 10-year forward PPA offer to Cherokee that we countered 1 week later. And I think it was talked about those, call it Duke's offer, and then our counter offer were approximately on an 8-6 basis, $1 million apart on an annual basis. Our counter offer was 37% lower than what Duke, our current rates under the current PPA are. Duke's offer was slightly lower than that. And in absolute terms, was about $1 million. And what that means on a residential bill, as we calculate it, is a penny a month. So what we offered was about 4 cents lower a month on an average residential bill. And then Duke's offer was a penny lower than that. So in the context of rates and trying to go back and forth, you know, frankly, we were hoping we could negotiate and reach resolution. Duke's position, like we've heard numerous times, was we can't negotiate avoided cost rates. And I think that's a good standard for negotiations in these cases. But the FERC mandate is just and reasonable rates and that are in the public interest. And, you know, from the perspective, and I know there's been some questions about, you know, do we make money with ready ice, for example? We make no money on our ready ice arrangement. We actually lose money. It costs us money to subsidize their operation. Many QFs that were developed, especially around the time of Cherokee, developed these steam post facilities, and they would subsidize those facilities so they could become a qualified facility and then try to secure a contract with the utility. That was the case way back in the 90s when this facility was developed. And those arrangements between ourselves and Ready Ice are still basically the same. So we're not making money. We're trying to secure a contract to really keep this facility operational for the next 10 years. That's our goal here. I know we're a for-profit company. I would be lucky even after 10 years if we were able to secure a contract at our September 2020 offer that we put to Duke to see a penny come out of this after we pay off the debt on the facility and pay our expenses. So that's the reality of the situation. That's not Duke's concern. That's just our concern is running a business. That may be a little more than what the question asked, but it's trying to give you a little perspective.
Perhaps a little bit more, but that's okay. I appreciate it. And this wasn't what I was going to ask you, but I think I heard you say that the proposed rate it would have been 37% less. I thought previously I'd heard Mr. Funk say 24% less. And I may have misunderstood that, but what's the difference between, what did I miss in those two?
So Mr. Strong's 25% less than the current rate was what he calculated the rates should have been if Duke offered us the appropriate avoided cost rates based on September of 2018. They would have been 25% lower than the current rates. What we offered to Duke in September of 20 was actually lower than what Mr. Strunk calculated. They were 37% less. And so we were really trying to get to a point where we could try to reach agreement with Duke. Unfortunately, there was, even though we were fairly close, there was no meaningful discussions following that. We really just got a response that we couldn't negotiate rates.
Okay, thank you. And now circling back to my original hypothetical, go back, say 2015 or say 2014 or whatever. And I think I heard you say that, well, I guess you could do that. But that's where I'm struggling, not saying you couldn't, but that's why I'm struggling to understand the practicality of that. In other words, if the electrical utility negotiates a 10-year contract with a QF, 10-year contract, and at year 2, the QF can stick a stake in the ground and say, no, I want this rate for the next 10 years. So in essence, instead of a 10-year contract, you have a 20-year contract with 18 years remaining on that avoided cost that's figured then. And I'm really struggling with that. Maybe that's the way everyone interprets FERC or whatever, but I'm just stunned that would be the case.
Well, I understand your concern, and I think kind of those protocols around, when can you establish a LEO, how soon in advance for a contracted unit. Most of the legally enforceable obligations are created for new facilities. So there's much more focus on new facilities being developed because they try to secure a contract that supports them actually getting built and then placed in service. It's different. I mean, I think the dynamic is a little bit different for facilities that have existing contracts, and when they get to their end of their term, I mean, our intent was it's not like in 2013, we submitted a LEO in 2014 or 15. We submitted a LEO after we met with Mr. Keene because we were discussing a subsequent PPA when our company met with him that previous summer. So there was no intent to try to stick a stake in the ground, anything more than we were already kind of starting conversations. So that's how you start the conversation for a QF contract. And that's what we were trying to do.
Thank you. So you're saying the September 2018 letter, that was the LEO, and I don't have it here in front of me. I just don't recall it, honestly. I think Duke's argument is that there was no legally binding obligation because there was no absolute guarantee that you were going to provide them that service, that energy.
I believe that's their argument, yes.
Do you agree with that argument? I know it's just probably a silly question to ask, but
I do not, and I think the reason is when FERC established the concept of a legally enforceable obligation, and correct, this is my understanding, I've developed and worked with QF plants probably for 20 years now. But when they established this concept, because back when PERPA was first instituted, there was a lot of gamesmanship and stalling and blocking of utilities didn't want to contract with third parties because it is more profitable for them to build their own facilities. They get to increase their rate base and earn returns on that. So there was a lot of gamesmanship in those early days, and the creation of the legally enforceable obligation, as we've talked about here in this case, creates that stake in the ground. So to say, you guys can screw around all you want for as long as you want, but you have to go back to that date because that's when you created that obligation. That's when the legally enforceable obligation was created. And unfortunately, it's been left to the state commissions to try to sort that out and how that would get implemented and resolved. But that's my understanding of why the concept of the legally enforceable obligation exists. And frankly, as part of this process, and as Mr. Strunk just testified, some of the offers, the form of contracts, even though we've frankly been somewhat of a dispatchable facility since the year 2001. And the letters that come along with it is take it or leave it, expires in 60 days, doesn't provide for really much negotiation room, which was not the case when we negotiated our agreement in 2012. There was actually negotiation in person between the two parties. There were several terms. We were negotiating a new form of agreement, this dispatchable agreement. And the rates were talked about between the parties. So, their position is their position, and that's fine. But I don't agree with it for sure.
So you're saying that you believe your 2018, September 2018 letter did definitively guarantee that obligation, that there was no doubt or question?
That is correct. We were committing ourselves to sell power to Duke, and then, they suggested we sell power to DEP instead. We went there. Ultimately, we came back to DEC because of the transmission issue that we couldn't resolve that we just discussed. But that doesn't change the establishment of the legally enforceable obligation. And we did not offer our output to anybody other than Duke in this entire period that we're talking about. And I think there was reference to a FERC case where said we could sell our output to third parties. That was in reference to whenever the PPA ends. When it ends, we could do that. I mean, it would be prudent from anybody running a business. If they can't sell their power to someone, they would go try to find to Duke. Then we would go try to find, we could sell it to somebody else. And we would do that if the PPA terminated.
So do you understand, or I'm sorry, I said, do you understand or agree that Duke Energy Carolinas and Duke Energy Progress are two separate companies?
They are two separate utilities, and they do integrate a lot of services back and forth between each other, as well as they, under the joint dispatch agreement, attempt to optimize, energy supplies between the two utilities. I do.
Yeah. One final thing. I think Duke witness Ms. Bowen mentioned an OAT. I think that was OATT, that acronym, and to be honest, I've already forgotten what the acronym was. I know what the intent was, but I don't remember what the acronym was. Did Cherokee apply for this OAT through DEC? Did they apply for this?
So what we were talking, under their OAT, which is their open access transmission tariff, that is governed by FERC, there are several services that they provide under that. One is point-to-point transmission. And for a facility like Cherokee, if we applied for that and paid for that, and just to give you numbers and why you can understand it wouldn't be commercially viable for us to procure point-to-point transmission. Under the offer that we made to Duke in September of 2020, total fixed payments under that would be about $7.5 million. Point-to-point transmission would cost us approximately $3 million a year to pay to Duke just to move the power from DEC to DEP. An alternative that is also available under their code is the ability for DEP to designate Cherokee as a network resource. If they did that, we would then have to pay network transmission charges. Those charges are, call it a couple $100,000 a year, significantly cheaper. And they would probably be a level that would be acceptable to us, where we could continue with the avoided cost rates provided by DEP to potentially be able to negotiate an agreement that would, be viable for Cherokee. So what really led us back to DEC was Duke was unwilling, or DEP was unwilling, to designate Cherokee as a network resource as part of the PERPA contract negotiations. And so the cost prohibitive nature of that type of transmission, the point-to-point transmission, made that not a viable alternative for us.
Well, this is probably a question to do, but I didn't think about it then, but I'm hearing what you're saying. I guess it sounds like, since you would be using DEC's transmission lines and avoided line loss and such as that, I assume that's where the difference would be. But does that make sense? Why they would have a different cost?
I think it's just the type of service that Duke can provide to a customer if it chooses to. We have other facilities in the Southeast and Midwest that, when we enter the contract arrangements, utilities or municipals designate our facility as network resources and utilize the capability of their transmission system to be able to transmit that power, and the rates associated with that type of service are much lower.
Yes, I appreciate it. You've been patient. It's almost 5 o'clock on a Friday, and I suspect everybody's pretty upset with me right now. So I'll not ask any more questions. Thank you a lot, Mr. I appreciate it very much.
Mr. Chairman.
Commissioner Thomas.
A little additional information on the relationship with the ice plant. But I'm looking at your rebuttal testimony where you talk about what would you like for the commission to do. And you summed it up pretty well in a sentence on page 17, the last page of your rebuttal testimony. It says, Cherokee requests that this commission direct Duke to offer a 10-year PPA under a tolling agreement structure like that which Duke finally offered to Cherokee in January of 2021, but to revise contract price to match Duke's avoided costs as of September of 2018. So I guess what I'm thinking then is that obviously you all see the September 2018 as the Leo date, and I'm kind of trying to fill in some blanks. At least there seem to be blanks in my head. So if we were to do that and go to the 2018 date, then it seems to me that it would be appropriate to use the integrated resource plan that was approved and effective at that time to establish when is the capacity part due, which if I remember correctly was 2028. And then you carry it another step further, and I believe that we have the flexibility to or we're required to update the avoided costs every 2 years, which would go through that process of adjudication that Mr. Strunk was talking about earlier. And that, so I think we would have the option to say, okay, then we'll do the updates to the avoided cost and apply those every 2 years once they become approved and effective. Is that something that you think could pass muster?
I'm not sure I followed it all the way through. Typically, what I communicated here was that we should step back in time and look at what were the needs and what were the rates that would be calculated for the 10-year PPA in September of 18. Duke could do that very easily. I believe the need in the approved IRP at that point was actually sooner than 2028. It was the draft IRP that Duke first in late 18, I don't remember the exact date, showed a 2028 need date, but that wasn't even resolved and litigated, and the result of that wasn't resolved until late 2019 and early 2020. So ultimately that need date was 2026 instead of what they first put out in their draft IRP. And the need in the prior case, I believe, showed 2025 subject to check. But I would step back to that point in time and have them calculate their avoided cost rates for the 10-year dispatchable tolling PPA and determine those rates. That still has not been done. And you know, in the alternative, we think, as Mr. Strunk testified to, the result of that would be, as I just talked through, would be a 20%, 25% reduction from current rates. I mean, we offered 37% reduction from current rates. So we could do that. I would, that would be, as far as the case stands, that would respect the legally enforceable obligation. And I think from a purpose perspective would be the correct way to do that. But I think we, as we've already shown, would be willing to enter into a contract that has a lower rate. And forgive me, Commissioner, I didn't understand the subsequent every 2 year, how that would impact a contract rate for the next 10 years.
Well, I'm not sure I do either, but one of the points that I thought Mr. Strunk was trying to make is that Duke keeps modifying assumptions every time they put numbers out there to you all, and that they haven't really gone through the process where ORS and everyone gets to say these numbers are good or they're not. And so my thought process there was we direct the way this worked be that every 2 years, once those avoided costs have gone through the process of being approved, then that part of the contract changes to the newest rates. And then that keeps that current every 2 years, which could be to your benefit or the customer's benefit. We don't know, but it keeps them fresh. And it just seems more appropriate, or certainly a potential way to look at it would be those get redone and reapproved every 2 years. Maybe have the contract so that it is updated every 2 years to reflect what has been approved. That's what I'm trying to say, I think.
Understood. And I think, and I'm sure you all as the South Carolina Commission have been involved with many of these establishment of these avoided cost rates and what kind of the certainty of the contract rates for the term mean for small businesses, either the solar business or Cherokee, for example. I mean, revenue certainty over time is important, and I think one detriment to what you suggest, Commissioner, would be lost. And if you did that with kind of the solar facilities that are getting built in state, they wouldn't be able to go out and finance contracts because there would be no certainty of what the revenue stream would be in the future. So I understand what you're saying. I just think from a, business operations perspective, it provides some other challenges.
Okay, I appreciate that. We're supposed to be thinking about the ratepayers as well, so I'm just trying to balance it out. That's where I was coming from. I appreciate your help. Thank you. And we're real close to happy hour, so I'm going to stop.
Thank you.
All right. Any other questions? Sir, I have a couple of questions for you. We spent a majority or significant amount of time during the course of this hearing discussing the LEO, and whether or not it was established or not. Wouldn't you agree?
We did.
Do you think it would be wise for the commission to, this commission, the Public Service Commission of South Carolina, to try to identify or implement a measure that would require a QF to file a letter or a document, maybe even with the commission or at least to the utility that clearly states that they're ready to enter into a contract so that it'd be easier and cleaner to establish the LEO date?
Well, I think it's generally been established for the small under 2 megawatt folks, because that's the form that Duke uses, and that's what the small generators use to create that commitment. What is confusing in this case is because we're over 2 megawatts, we use the same form and provide the same information, and it's not respected as creating that LEO. But I do think, it's clear in this case that protocols around what it means to establish a LEO for facilities greater than 2 megawatts seems to be an area of confusion, as well as not only how to create them, but when you can create them, as we've discussed in this case. I think that would be helpful for moving forward with other issues at the commission, if that was developed.
Understood. Thank you. Any other questions for this witness? All right, sir, you may step down. Please call your next witness.
Mr. I'm sorry, Mr. Chairman, I had just a couple of redirect questions.
Oh, go right ahead, Attorney Pringle.
Thing to say at 5:02, but I will be as very brief. I don't have a good metaphor at this point. Mr. Hanson, you had a discussion with Commissioner Caston about several of the offers that were provided both by Cherokee and Duke Energy Carolinas. Do you recall that?
I do.
Okay. Was the February 10th, 2021 offer from Duke Energy Carolinas the best offer from Duke Energy Carolinas that Cherokee received?
No.
Okay. It was not as good as the offer you described previously in your conversation with Commissioner Caston?
No, in our view, the best offer that we received from Duke over the entire period was the verbal offer that they made in September of 2017. September, sorry, let me get my dates right. The verbal offer they made in September of 2020, I believe it was September 17th. And that was the best offer that they made. And that's the one we countered with a week later. And that's where the difference between those two offers was about $1 million a year.
Okay. Similarly, and hearkening back to your conversation also with Commissioner Caston and maybe others about your establishment of the LEO in 2018, would Cherokee be worse off if a LEO was created in 2018 from a rates perspective or a avoided cost pricing perspective?
Our view is no. I think Mr. Strunk talked to that. But Mr. Strunk, you know, in his calculations determined it would be about 25% lower than what the existing rates are, but which is higher than what we offered in September of 2020. So
okay.
I don't think we'd be disadvantaged.
All right, last question. And it's certainly one, and you described some of the back and forth and what took place, and you were understanding that there weren't meaningful negotiations. Why would Cherokee wait until November of 2020 to file a complaint with this commission?
You know, because, you know, we were exchanging offers as late as September of 2020. Our view is as I think everyone that's participating in this hearing, this takes up a lot of everybody's time. It's not in the best interest of our company and or all the folks that work for Cherokee or the commissioners or ORS. So we were trying to work it out and negotiate a solution that would be viable for Cherokee to continue to operate for the next 10 years. We didn't determine that until we got a response after we submitted the September 25th, 2020 offer to DEC. Once we had that follow-up conversation that they weren't willing to negotiate anything further than what they offered us, we felt the only way to try to resolve the discrepancy here was to file the complaint at the commission. That's why we waited so long, because we were trying to resolve it between the parties before going to the commission.
Thank you, Mr. Hanson. That concludes my redirect, Mr. Chairman.
All right. If there's nothing else for this witness, you may step down, sir.
Thank you.
General Counsel Western Hill, have you already discussed with the parties expectations when it comes to proposed orders and briefs? If so, we don't need to discuss that now. We can adjourn for the day.
Yes, sir, Mr. Chairman.
Adjourn. All right, we're adjourned.
Thank you, Mr. Chairman.